Lord, on behalf of Union of India, Lord, I am giving both sides of the picture. And I must start, my Lord, by...
Yeah, I went through your written submissions.
My Lord, your Lordships can rest assured, I am not going to read everything, my Lord. I have deducted most of the things in reading, but everything should be there. And I'll tell your Lordships the purpose behind it. What is the significance, my Lord, of this? And what responsibility we on both sides carry to assist your Lordships.
Lord, just for clarification, mine is a lead matter. We have filed our written submissions in
That's okay.
Let him start. We'll make submissions after him.
Yes, of course. Lord, our response, why this is long and I'm not going to read, my Lord. Lord, the issue which my Lords are, my Lord, deciding is going to be a seminal importance for one reason, my Lords. Lord, in the world, we have checked up, my Lord, all jurisdictions, other countries also. Broadly, they can be classified in two categories. One set of countries who have adopted UNCITRAL Model Law, and another set of countries, which are very few, who have modified their respective statutes to suit their domestic needs. Having examined both the statutes, which I will place, my Lord, whatever is relevant, only peri materia provisions of Section 34, all judgments, my Lord, whichever we could lay our hands on, we have, my Lord, tried and find out. In none of the jurisdictions, the question which your Lordships have referred is answered. So whatever your Lordship decides is going to be the first. And since, my Lord, there are large number of countries who have peri materia provisions to our Section 34, my Lord, that would be cited. My Lord, therefore, my Lord, we have tried to encompass, my Lord, the views of other jurisdictions also, so that your Lordships can get, my Lord, complete assistance from, my Lord, all points of view, and your Lordship's judgment, my Lord, is accordingly, my Lord, modified. Now, my Lord, my submissions would be, my Lord, in three broad categories. Number one, Lord, without examining the history of Section 34, without examining the provisions of the Act of 1996, historically, it may not be possible for your Lordships to examine in isolation Section 34, its contours, and answer the question whether it encompasses the power to modify the award. So that would be, my Lord, my first set of arguments.
You see, Mr. Solicitor, there are three things. Why we have expedited the matter is there are large number of issues, there are large number of awards. Arbitration awards in commercial matters is normally commercial agreements. This is the way most of the parties have been till now in India getting their disputes resolved. This matter is coming up in large number of cases.
Correct, my Lords.
Almost every week, probably in Supreme Court itself, there'll be about 3 or 4 matters in which this issue.
The High Court, much more, my Lord. Your Lordships are right.
And the High Court, maybe more. Arbitration is expensive. This cost factor is one of the bigger things. At the same time, it's quite clear the courts are not an appellate forum. Neither we exercise the complete power of appeal review. So we have to find a way out to deal with this problem. Where do courts interfere? Where do courts do not interfere? New bill which is now introduced, we should not be commenting on it because we don't know what's going to happen, and in any case
there is an appeal provision, etc. But
no, we are not concerned with the appeal.
It can be tweaked, it can be
no,
changed,
we are
modified,
not on that.
etc.
But you're not on that.
Your
But
Lordships are right.
But as far as this question is concerned, there are some amendments. I think one of the Union of India councils has, in their written arguments, referred to that. The new amendment.
Yeah, my colleague, my Lord, Ms. Dave mentioned it.
Probably you have, in your case, you have referred. So, one is, we are not saying what do you mean by modification? And to what extent, if we accept partial modification without changing the substance of the award, without changing the core of the award, what will be the permissible parameters? First is, What do you
First
mean by,
threshold.
first is what is the, whether the threshold can be, because as far as severability is concerned, segregation is concerned, some of the written arguments accept that. Perhaps most of the written arguments accept that.
I have also accepted with one caveat that severability is for setting aside, not for modifying, in the sense that if there are 5 claims.
Now
and-
you may proceed. Now you may proceed. in your-
Yes, I'll bear, my lord, what is in your lordship's mind. My lord, kindly allow me to give a little history, my lord. I'll give the history. Thereafter, I'll show to your lordships, my lord, the provisions of other jurisdictions where the UNCITRAL model law is followed by their respective legislatures. And there are 5 or 6 countries, which includes United Kingdom, France, Canada, United States, etc., where they have suitably tailored their respective legislations without not going by strictly the UNCITRAL model law. And third, my lord, my submission would be, my lord, that what can be the contours of your lordship's examination on answering the questions whether there is a power of modification or not. Because, my lord, it is my respectful feeling also, my lord, that some judicial oversight is necessary even to boost the arbitration. Lord, right now the position is that even arbitral tribunals are aware that 34 is almost a needle of the eye test, and therefore virtually the award is going to be final. And therefore, my lord, situations sometimes arise that the parties are not satisfied for more than one reasons, and that, my lord, kind of acts as a deterrent in going for arbitration. So the government is also interested in solving the problem. The question is how and by whom. Lord, now, Lord, our arbitration goes back, and I'll not, Lord, say anything which is not relevant for answering the question before your lordships. Our arbitration statutory journey, my lord, is from 1899. Indian Arbitration Act 1899 was the first. The purpose of showing, my lord, 3 sets of legislations in India for arbitration is to show that whenever the statute intended that there has to be a power of what they call varying the award, which we, my lord, in other words, say modifying the award. Lord, they have stipulated not only the power, but the contingencies under which it can be exercised.
Yes.
Lord, please directly come to, and I can again, my lord, assure your lordships, I will not read the whole thing, my lord, but whole thing should be before your lordships, when your lordships examines the matter and decides it, my lord. While delivering the judgment, your lordships must have everything on the table. That's the purpose, my lord. My lord, kindly come to para 3 directly. My lord, this is Arbitration Act of 1899. My lord, at the outset, I must say one thing, my lord. In the written submissions of my learned friend, Mr. Gaurav Banerjee, my lord, I find a very interesting and a very apt, correct line, my lord, at the end. I'm sorry, my lord. Mr. Banerjee's submission ends with a very intelligent, very correct, and very interesting line that over intellectualization of arbitration is India is the real problem. That's what, my lord, he has said. My lord, I'll take care that I do not fall into that. My lord, that was, my lord, I am told, my lord, by my lord Justice Narasimha. He has said that, my lord, but I'll add over intellectualization of anything in anywhere, any part of the world is generally the problem. But now kindly see, my lord, page 3. This is what, my lord, the provisions were. My lord, your lordships are at page 3. Right side bottom is the pagination.
Yes.
Power to remit award. Lord, this is 1899 Act. The court may from time to time remit the award to the reconsideration of the arbitrators or an umpire. Where an award is remitted under subsection 1, the arbitrators or umpire shall, unless the court otherwise directs, make a fresh award within 3 months. Lord, here there is no modification power, your lordship would mark. Lord, it comes in 14. which is widely construed by judgments, my lord, where an arbitrator or umpire has misconducted himself or an arbitration or award has been improperly procured, the court may set aside the award. So this again is power of setting aside, but improperly procured is very widely construed by various judgments. My lord, improperly procured would not mean, my lord, in the linguistic sense of the term, but it would mean that there was no valid arbitration, the contract was not valid, the arbitral tribunal has traveled beyond the scope of the reference, etc., etc. And, my lord, I have cited judgments, my lord, how it was widely construed. These are all, my lord, British judgments, because 1899, my lord, we had the British regime in place. Now, your lordships may kindly come to page 4. In that, my lord, 1899 Act had one schedule appended to the Act, which provided that these provisions of the then existing Civil Procedure Code would be applicable. That is, my lord, at the foot, my lord, page 4. These are provisions of the second schedule, which, my lord, incorporates by reference the provisions of the Code of Civil Procedure 1908, where the award or matter referred to arbitration may be remitted. The court may remit the award. My lord, remission is not right now, your lordships, my lord, scope of examination. Therefore, I'll skip. Kindly see 15. Grounds for setting aside award. An award remitted under paragraph 14 becomes void on failure of the arbitrator or umpire to reconsider it. But no award shall be set aside except on one or following grounds: corruption or misconduct of the arbitrator or umpire. My lord, very bold ground, my lord, specifically raised, specifically provided, B, C, etc. Lord, your lordships are not concerned with the grounds, because what I am respectfully trying to, my lord, show is that the power was setting aside of the award. No variation, no modification, no change, whether for good reasons or otherwise. Now comes, my lord, our Act 1940, which, my lord, which is the predecessor Act to the present Act. The lordships may directly come to page 6 now. Page 6. Lord, this held the field from 1940 to 1996.
Perhaps earlier. Because there was an ordinance, there were a number of acts which came.
The 95 ordinance. But Act.
That makes no difference.
No, that doesn't make any difference, because 96 Act repeals this Act. So it continues, my lord. Lord, 14, I have, my lord, cited for completeness. Award to be signed and filed. Lord, your lordships need not read it. I'll just orally point out what the scheme was. Once an arbitral tribunal makes an award, it was directly not enforceable the way, my lord, we do it now. The arbitral tribunal was under a statutory obligation to place it before the competent court for its affirmation. And it became a decree of the court only when the arbitral award passes through that test, which is laid down in section 15 and 16. Nothing turns on that. That was the scheme. That it was not the moment award is passed, it didn't become the decree. It has to pass the scrutiny. But please see, my lord, section 15. The lordships have section 15. Power of the court to modify the award. The court may, by order, modify or correct an award where it appears that a part of the award is upon a matter not referred to arbitration, and such part can be separated from the other part and does not affect the decision on the matter referred. Well, two things: specific power of modification conferred, and second, the severability or separability consistently, my lord, runs through 40 Act, UNCITRAL, and our Act, which I'll show. Meaning thereby if they are so intermingled that they cannot be separated or severed, then it cannot be modified. That was how, my lord, this statute was judicially examined and interpreted. Where the award is imperfect in form or contains any obvious error which can be amended without affecting such decision. C. Where the award contains a clerical mistake or an error arising from an accidental slip or omission. Now it is section 33. But it was a part of modification power of the court when the court is presented with an award for making it a decree of the court. So before making it a decree, there was a power of modification in 1948. Then 16, power to remit the award. The court may from time to time remit the award or any matter referred to arbitration to the arbitrators or umpire for reconsideration upon such terms as it thinks fit. Since the questions which are referred, my lord, does not pertain to power of remission, unless your lordship, my lord, would like me to assist, I may skip this. Because that your lordships are considering whether modification power exists or not. Power of remission, my lord, is retained to a, my lord, limited extent even in the 1996.
If it has relevance, then you please address it. If you feel it may not be, some of the council may refer to the power to remit.
Let me, my lord, then point it out, my lords. Because remission would not include power of modification. Modification would mean without doing anything more, the 34 court itself modifies, changes, varies the awards. Not power of remand, that we find this lacuna, I send it back, you correct the remand. Right now we are concerned whether 34 court itself can modify, vary or change the award. But my lord, let me read 16. The court may from time to time remit the award or any matter referred to arbitration to the arbitrators or umpire for reconsideration upon such terms as it thinks fit. Where the award was left undetermined, has left undetermined any of the matters referred to arbitration, or where it determines any matter not referred to arbitration, and such matter cannot be separated without affecting the determination of the matters referred. So again, severability was, my lord, a part of the exercise of the power. D, where the award is so indefinite, so as to be incapable of execution. There may be, my lord, such instances where it is so nobody can understand how to enforce it. While an objection to the legality of the award is apparent on the face of it. 2. Where an award is remitted under subsection 1, the court shall fix the time within which the arbitrator or umpire shall submit his decision to the court, provided that any time so fixed may be extended, etc. An award remitted under subsection 1 shall become void on failure of the arbitrator or umpire to reconsider it and submit his decision within the time fixed. Then, my lord, judgment in terms of the award. Now it becomes enforceable decree in eyes of law, where the court sees no cause to remit the award or any of the matters referred to arbitration for reconsideration or to set aside the award. The court shall, after the time for making an application to set aside the award has expired, or such application having been made after refusing it, proceed to pronounce judgment according to the award, and upon the judgment so pronounced, a decree shall follow, and no appeal shall lie from such decree except on the ground that it is in excess of or not otherwise in accordance with the award. But somewhat similar to section 37 of the present act was absent there. It was almost final except this limited, my lord, ground of appeal. My lord, 18, I am not touching power of court to pass interim award. This is section 30, grounds for setting aside award. Again, the grounds were only for setting aside, not for modification. Modification was 15 different grounds. Grounds for setting aside an award. Award shall not be set aside except on one or more of the following grounds, namely, that the arbitrator or umpire has misconducted himself or the proceedings, that an award has been made after the issue of an order by the court superseding the arbitration, or after arbitration proceedings have become invalid under section 35, that an award has been improperly procured or is otherwise invalid. This is peri materia to 34 of the present regime, my lords. So thereafter, my lord, I have shown, my lord, that
Also pari materia to section 15 of the 1900 Act.
no, I beg your lordship's pardon.
You had read the provisions from CPC, which are incorporated in the earlier Act.
1899 Act.
99 Act. So
1899 Act had an appendix, schedule appended to the Act.
this section 30 is pari materia to section 15, which was by incorporation in the 1949 Act.
Yes, yes, for setting aside, yes. Improperly procured, only two grounds are added. Award is made after the issuance of order of supersession. And yes, my lord, only one ground is added. Otherwise, your lordships are right. 14 of 1899 Act and 30 of 1940 Act is substantially the same with addition of one ground. My lords are right. But thereafter, my lord, I have given for your lordship's assistance, my lord, how 1940 Act, which provided for modification power, was construed by the courts, by Indian courts, my lord. Obviously, my lord, it was an act applicable to India. But, my lord, for the time being, I may skip that, my lord. There are three judgments. Only, my lord, one judgment, if your lordships can read, and that too the highlighted part. My lord, I have highlighted so as not to read the entire thing, while quoting the entire thing and annexing the judgment in my compilation, so that I'm not, my lord, nobody says that this was not fully pointed. But for easy reference, my lord, please come to page 9 at the foot. Lord, this is Ashok Kashyap versus Sudha Vashisht. The purpose of remitting the award is to enable the arbitrator to reconsider the decision where the legality was connected with the decision as contained in the award. It must not relate to a matter which has no connection with the decision or decree. Therefore, in our opinion, there was no scope in facts and circumstances of the case of exercising its powers by the High Court under section 15 of the Act and the powers under section 151. Lord, that was a case where the court modified the award and remitted also. The court said this is not, it's a very narrowly tailored statutory provision. Now, my lords, comes the main part. Why?
Yes, Mr.
Yes. My lord, thereafter, after, my lord, when this was going on, and there was, my lord, a kind of a feeling amongst the legal fraternity and the judicial fraternity that something needs to be done for the purpose of changing, modifying, etc. of the Arbitration Act of 1940. The question was referred to the Law Commission of India. And, my lord, we have 76th report on Arbitration Act 1940 by the Law Commission of India, my lord, penned by my Lord Justice H.R. Khanna. But I'll read only few paragraphs which are relevant for present controversy. Volume 1, page 231. My lord, my volumes are bigger, but I am going to read few pages only. My lord, I cannot be selective in filing. The filing has to be the entire report, my lord. It cannot be selective.
Volume?
Volume 1, page 231. Lord, it starts at page 208. But I am taking your lordships only to chapter 5, because chapter 5 is proceedings in the court on an award. Rest is, my lord, duties of arbitrator, how other things needs to be tweaked, etc. Page 251, I'm sorry, my lord, my copy is little not, my lord. It's 251, page 251. Right side top is the pagination. My lord Justice Sanjay Kumar gets 251. Para 5.1, thereafter I'll skip what is not relevant for the present controversy and, my lord, read what is relevant. After an arbitrator has, am I with your lordship?
Yes,
After an arbitrator has made his award, one of the parties must obtain a judgment in terms of the award. Indian law, as enacted in the Arbitration Act, does not allow a party to enforce the award as such. This position therefore necessarily requires the question, what are the possible alternatives open to the court when its aid is sought for the purpose of making a decree in terms of the award? It's not a challenge procedure. The award does not get finality unless it passes the muster of the court. And what are the available options before the court when such an award comes before it?
Normally, 33 would be filed, and 17 will be taken up together with that. 17 is the stamp of decree,
Correct.
but whenever the award is filed
Under 40.
under the 40 Act,
Under section 14 of 40.
14 of the 40 Act,
Yes.
wherever the party wants a setting aside, section 30 read with 33 objections would be filed.
Would be fine.
To be taken up, and on the ordering of the objection and depending on the result, 17 would follow.
Correct. It would be either made decree of the court, setting aside partly, rule of the court, setting aside partly, affirming partly, and for limited grounds, even modifying, because there is a power of modification. There was a power of modification. Now, my lord, come to last but one third para, unnumbered para, the second situation. Lord, I'm skipping, my lord, what is not relevant for the present.
yes,
The second situation is equally unobjectionable since the power to modify or correct the award is, in this case, linked up with an imperfection of form or an obvious error and can be exercised without affecting the decision on the matter referred. The situation where an award contains an obvious error is illustrated by a series of cases where the award was erroneously passed against the President of India, while it should have been passed against the Union of India. The third situation becomes necessary by reason of the fact that the award, because of clerical mistake or accidental slip or omission, does not reflect the true intention of the arbitrator. The common link underlying the three situations is the legislative policy of giving effect to the substance of arbitration and the award. It may be noted that section 15 corresponds to the Code of Civil Procedure 1908, second schedule para 12. There was no such provision in the Indian Act of 1899. It was, my lord, by way of reference by incorporation. The schedule was an annex to the Act. Nor is there any such provision in the English Act. Under the English Act, the court has no power to alter or amend an award. It may be noted that even in India, no such provision was contained in the Code of 1882 in relation to the arbitration without intervention of the court, and therefore the court had no power to amend the award to or remit it. It could either file the award or reject the application. In absence of such a provision, the court had either to set aside the award or to remit it. Hence, the need for a provision conferring power to modify the award. The present provision is a salutary one, and we have no change to recommend in section 15. Lord, section 15, your lordships would recall, is a power of modification of the award on the grounds mentioned therein, my lord. Then at the foot of the page, 5.7, it may be noted that in the Indian Arbitration Act of 1899, there was no limitation of the grounds for remission. 13(1) of that act was as follows. My lord, ground remission, my lord, your lordships are not right now considering. I'll not, my lord, go into that, my lord. Lord, if your lordships, my lord, would consider partial remission, etc., my lord, there is a detailed discussion by the Law Commission, my lord, at page 255. But since remission may perhaps not have the relevance, but since other side may, my lord, put it, therefore, for completeness, I may read para 5.14. The reconsideration under section 16 may be the whole award, or it may be of a particular question only. If the whole award is remitted, the effective award is the second one. But if only some of the matters are remitted, it becomes somewhat difficult to decide how far the first award remains effective. The question was discussed in a Calcutta case. The view was taken that unless the court gave a direction under section 16(1) to the effect that the award of the arbitrator should be limited to the matters remitted to him, the arbitrator can, in his second award, confirm or repeat what he had said in the first award. And skip the remaining two para and kindly come to 5.17. We may now revert to the need for widening the scope of section 16, a matter which we have already discussed. It is to be noted that at present, when an award which is defective in matters of substance is received by a court, when the only alternatives open to the court are to remit the award or to set aside. Power to set aside the award, in contrast with the power of remission, is a drastic one, because the court may then supersede the reference and direct that agreement ceases to have an effect with respect to the difference referred. Such a drastic action may not always be in conformity with the intention of the parties. It may lead to unnecessary litigation and in some cases to injustice. If this approach is correct, the power to remit should be worded widely rather than narrowly. In fact, this power in the earlier act, Indian Arbitration Act 1899, Section 13, was very wide, because Section 13(1) of that act provided that the court may, from time to time, remit the award to the reconsideration of the arbitrators or an umpire. There was no further limitation as to the grounds of remission. In the English Act also, the power is expressed as a power to remit the matters referred or any of them without any restriction as to grounds. Now, my lord, this may perhaps not survive, because now much water has flown and this issue is also debated and discussed in UNCITRAL, my lord, which came out ultimately with the model law. But I don't think any other part of, my lord, this report would assist your lordships, my lord, or the other side, my lord. Either way, my lord, it would not be of much assistance. Now, kindly come back to my note, my lord. Now, my lord, I will show how the model arbitral UNCITRAL law, UNCITRAL or UNICITRAL, both, my lord, words are in vogue, came into being, my lord. Because there were page 12
Of the note.
of the note. Lord, I may say there was a detailed exercise undertaken by the UNICITRAL. Several working groups meetings took place. Several discussions took place. India also participated in discussion. Other countries also projected their respective difficulties in their domestic arbitrations, international arbitrations, etc. And keeping everything in mind, this UNICITRAL model law was framed, leaving it open for the member states. When I say state, state in the international law parlance, member countries to adopt it fully, partially, or not to adopt it. Lord, kindly come to page 13, para 39. Lord, everything which we now see as Article 34 of UNICITRAL and our Section 34 of the Act is essentially based on New York Convention. Lord, your lordships are aware, New York Convention was essentially for the purpose of enforcement of foreign awards. It did not provide for any challenge procedure, etc. But if it meets with the following conditions, a foreign award can be enforced in another country. Lord, that is Article 5, which I have quoted. Lord, this would be relevant because your Lordship would find this reference subsequently when the UNCITRAL Model Law is in the making. Lord, kindly see at the foot, para 39. Before the UNCITRAL Model Law for domestic arbitration or international commercial arbitration, the only major international convention on the subject was New York Convention, which dealt with enforcement of foreign awards. Articles of the New York Convention provided the scenarios where the foreign award could be refused to be enforced. Something similar to 34, that if these are the grounds, we will not enforce it. Please read, Manoj. Recognition and enforcement of the award may be refused at the request of the party against whom it is invoked, only if that party furnishes to the competent authority where the recognition and enforcement is sought prove that the parties to the agreement referred to in this article in Article 2 were under the law applicable to them under some incapacity. This is one of the ground, my lord, in 34. Just followed as a side reference. Or the said agreement is not valid. Same again. Under the law to which the parties have subjected it to, or failing any indication thereon under the law of the country where the award was made, or B, the party against whom the award is invoked was not given proper notice of the appointment of arbitrator or arbitration proceedings, or was otherwise unable to present. This comes, my lord, in 34, Article 34 of UNCITRAL, which we follow under Section 34. Even incidentally, the section is also same. Number same. The award deals with a difference not contemplated by or not falling within the terms of submission to the arbitration. Well, that is terms of reference. Or it contains decisions on matters beyond the scope of submission to arbitration, provided that if the decisions on matters submitted to arbitration can be separated from those not so submitted. So severability was sine qua non. That part of the award which contains decision on matters submitted to the arbitration may be recognized and enforced. If it is not severable, the entire award will become unenforceable. This continues in 34. I'll show this. The composition of the arbitral authority or the arbitral procedure was not in accordance with the agreement of the parties, or failing such agreement was not in accordance with the law of the country where the arbitration took place, or the award has not yet become binding on the parties, or has been set aside or superseded by a competent authority of the court. Lord, two, we are not concerned. Lord, at this stage, my lord, a need was felt. But I'm not going into the history because that's not necessary. But this is the period of time where, my lord, these are late 50s, where inter-country trade and commerce became, my lord, the rule of the day. And therefore, the arbitration and more particularly the international disputes between one party in one country and another party in another country started growing. That required a global framework that you provide for one model law, because each country has their domestic arbitration laws which are at variance with each other. And therefore, my lord, the UNCITRAL was tasked with the functioning of preparing a model law which can be prepared as a model, and member countries can either with modification or without modification accept it in their respective parliamentary legislation, or they may choose not to. My lord, kindly take volume 2. Volume 2 again is big, but I am going to read only 7 to 8 pages, some paras from those pages. But I have to put complete working group minutes, my lord, so that your lordships have the fuller picture. Please come to page 501. Lord, the effort starts from 1976. para 49. My lord, this is the Asian African Legal Consultative Committee initiated the discussion with UNCITRAL. That's the limited purpose of my showing.
501.
But
Correct. 501.
501 para 49. My lord, this is Asian African Legal Consultative Committee. They initiated that UNCITRAL should now come up with a model framework, model law, which can be utilized by the other countries. The problems encountered are sometimes due to the fact. I'm sorry. My Lord Justice Sanjay Kumar has 501 para 49. I'm not reading the whole, my Lord. It discusses the need for having a common my Lord, model law, but 49 is relevant. The problems encountered are sometimes due to the fact that 1958 Convention, that is New York Convention, does not regulate certain issues. This has on occasions led to uncertainty about the applicable law, that is, in respect of the validity of arbitration agreement, and due to the disparity of national laws to different results. One possible way of important could be to attempt to reduce that disparity by recommending uniform rules which would take into account the specific features of international arbitration agreements and awards. That would be in conformity with the discernible trend of national restraint in international context. Kindly now, my lord, come to page 502 at 503. My lord, the Secretariat of UNCITRAL, my lord, prepares this note. Para 8, my lord. Para 8 at 503. I'm skipping something, my lord, your lordships can take it from me. Would not be relevant either for this side or that side. My lord, I am presenting everything in a neutral way. 8. Yet another reason is the divergence existing between frequently used arbitration rules and national laws. This is the area of concern expressed by AALCC, that is Asian African Legal Consultation Committee, in its recommendations. For example, some national laws restrict the power of parties to determine the applicable law. Some national laws do not recognize the competence of arbitral tribunal to decide about its own jurisdiction, or they provide for judicial control over the composition of the tribunal and sometimes even over the application of substantive law. Other laws establish certain nationality requirements for the arbitrators or require the award to be accompanied by a statement of reasons irrespective of any agreement by the parties to the contrary. It is suggested that an UNCITRAL model law on arbitral procedure would, if implemented at the national level, solve many of the problems referred to. It would also establish universal standards of fairness and would thus meet the concerns expressed in one of the proposals of AALCC. Moreover, such a model law would prevent some, if not all, of the difficulties detected in the survey on the application and interpretation of 1958 New York Convention. Finally, the elimination of certain local particularities in national laws, a model law would be relevant in the context of the proposal of ICC to limit the reasons for setting aside awards to the grounds for refusing recognition and enforcement specified in Article 5, Paragraph 1. I read Article 5 of the New York Convention. This is the beginning where the thought process started that even if you give the power of setting aside or you provide for a judicial oversight for setting aside, restrict it to the grounds referred to in 5. Therefore, I read 5 because that is the genesis, that is the foundation of this thought process. If the Commission were to agree with the above recommendation, it may wish to request the Secretary General A to prepare an analytical compile. My lord, your lordships can skip that part, my lord. Now, please come to, my lord, the Secretary General now prepares a report on 14th of May 1981, which starts at page 401, but kindly come to 519. 519. Lord, I'm skipping the rest because that's not relevant. It's because UNCITRAL was for everything. what is contract, what is arbitrable contract, how tribunal will be framed, how tribunal will conduct itself, when the tribunal's jurisdiction would end, when it becomes functus officio, fees, etc., etc. We are concerned with the recourse after the award is passed. That is, my lord, this chapter at page 519. Therefore, my lord, I am not reading the rest. 519, your lordships get, my lord.
Yes.
Means of recourse. My lord, from here till date, it's not power of appeal, right of appeal, right of revision, right to seek change modification. The expression continues to be recourse, which is, my lord, in my submission, a neutral term. What is the recourse? Then whatever is the power given will be exercised. Appeal against arbitral award, 102. I am on para 102. The question whether an appeal may lie from the arbitral award is relevant to the question at what point of time an arbitral award obtains the authority of res judicata, as it is called in Article 24 of 1966 Strasbourg Uniform Law, or becomes binding on the parties, which is one of the conditions for the award to be enforceable under New York Convention. As regards appeal to any second instance arbitral tribunal, the answer seems simple. The model law should recognize any such appeal if agreed on by the parties, as is not uncommon in commodity arbitrations. But Lord, kindly pause here for a minute. My understanding is what the UNCITRAL, the Secretary General is pointing out is there are arbitration agreements which provide for double-decker arbitration. If I lose arbitration once, the contract provides for an internal mechanism providing for an appeal remedy. It is that. There are two judgments of this.
Hindustan Copper.
Pardon?
Hindustan Copper.
Hindustan Copper. I recently
Two-tier arbitration.
Two-tier arbitration. I recently lost, Maluk.
Central trade.
On the lighter side.
You recently know, he lost quite some time back. He's just implementing it still.
Yeah, Maluk, 1 month back or so. Your lordships are right, Maluk.
That is the execution.
Yeah, we lost much
Upholding
earlier.
the two-tier arbitration.
Yeah, I lost in 2000 something, Maluk. Your lordships
There
are
was a
right.
conflict, it got resolved.
Only my presence was
Central rate.
central trade. Maluk, my presence decide Maluk, was the
No,
final barrier.
But probably this is what is referring to is something different. What it is referring to is the law of arbitration as applicable.
But
Not to, look, this is not referring to the execution part. It is referring to the first stage itself, which is the law of arbitration agreement as applicable in the country or the seat of arbitration.
correct. Your lordships are right.
Not referring to the enforceability part.
No. The law itself or the agreement itself provide for a two-tier arbitration, as my lord just.
No, even otherwise, the law will not, suppose, let's say, even in England, if I'm not mistaken, they have a concept, still have a concept where the award can be made rule of the court or degree of the court.
I will show the provisions in England. England have deviated from the UNCITRAL.
They have still a provision where you can make it a degree of the court. Then it becomes, or like here, suppose the award is pronounced here. Then you can find, or the seat of arbitration or the law of arbitration as applicable is Indian law to arbitration agreements. Then 34 will lie here.
And 36 also simultaneous.
34 will lie here. It is decided. Then the principle of res judicata will apply. But suppose you want to execute it, say, now in country A, which is a signatory to the New York Convention, in country A, the party which is defending can take recourse to 48.
Correct. Even we, in international
to that
arbitration, we
extent-
can take recourse too.
But till 34 is decided,
Correct.
possibly you can argue, you can't have that award enforceable in a foreign country.
Unless that country's arbitration law permits. For example, in an international commercial arbitration.
May not be, because if we go by what is stated over here, that recourse, because till then, it doesn't operate as res judicata. For res judicata, there has to be finality of proceedings.
Functus officio, the tribunal
So there
becomes
has to be finality of proceedings. As long the matter is sub judice, it's not res judicata.
the arbitral tribunal, the award is res judicata. The tribunal becomes
If
functus
the
officio.
award is under challenge and it is pending consideration of the appellate forum, say the appellate tribunal, or for that matter 34,
Correct.
it will not operate as res
As res judicata, but the tribunal would become functus officio. Therefore, that is also a discussion that while remitting, what happens because the tribunal no longer exists. Therefore, the word used is to resume, the court would direct the tribunal to resume the arbitration, not continue the arbitration because you have already become functus officio. Then, my lord, 103. The answer is more difficult, however, in respect of any appeal to the courts. My lord, this makes it clear that first was internal appeal under the agreement.
Let's be very clear. The appeals against an arbitral award is one chapter, which is one heading. The second heading, number 2, is remedies against leave or for enforcement. That's the execution part.
Correct.
So that's the first part deals with the appeals against arbitral tribunal, which can be to a appellate tribunal, arbitral tribunal, or maybe in form of appeals which are provided
In the law,
in the law of that country.
the statutory appeal of the domestic law.
Domestic.
My lord, instead of 34, we possibly, hypothetically, could have provided for an appeal, first appeal, my lord, against the order of the, against the arbitral award. That's correct. My lord, we agree on this side, my lord, that it should have. But that's, my lord,
What should have?
one appeal of right, my lord, that judicial oversight over the arbitral tribunal, my lord, is a must. My
It
lord,
should not be one-step adjudication. It should not be one-step
my
adjudication.
lord, the logic, my lord, as explained.
Anyway, that's a different question.
That's not, we are not concerned. But the logic, my lord, given by several courts in several other countries is why there is limited jurisdiction to interfere. The reason is the party autonomy. It is the parties who have chosen that instead of going before the regular dispute redressal mechanisms in the form of civil courts, we will have our own system. There would be a tribunal which would be consist of the members selected by us, and therefore it should be final and binding. Then you cannot have the recourse to the same procedure which you wanted to avoid. I wanted to avoid civil suit, revision against interim orders, then first appeal, then second appeal, then 136, and therefore we entered into the agreement that we would have our own grievance redressal mechanism, and therefore minimalistic interference. That's followed the view of almost all jurisdictions in the world. So then 103. The answer is more difficult, however, in respect of any appeal to the courts. Such judicial review on the merits, at least on certain questions of law, is envisaged under some national laws. Yet, as illustrated by the recent change concerning the most prominent example of special case procedure under United Kingdom law, there is a clear trend toward further limiting the control function of the courts in the international context. This development is based on the same considerations as the trend to restrictively apply any public policy ground, and that is the realization of the specific features of international commercial arbitration. In particular, its limited connection to any given domestic legal system. It is suggested, therefore, that judicial control on the merits be limited to the utmost. There are, of course, certain minimum standards which any state wants to see observed, even in international arbitrations. However, these standards, which form part of its international ordre public, my lord, it's public policy, my lord, we have checked up, my lord. Now, my lord, kindly see this next title. Is it public policy? Public order, but in this context, public policy. There can't be a public order issue in an arbitration. Remedies against leave for enforcement, that is executive. My lord, we are not concerned with this, my lord, therefore I will skip it. Kindly come to, my lord, page 520, heading number 3, setting aside or annulment of award. and similar procedures. Your Lordship gets, my Lord. The issues relating to setting aside or annulment of, my Lord, this is, the main title is means of recourse. First is appeal, second is enforcement, now third is setting aside procedure. The issues relating to setting aside or annulment of arbitral awards are amongst the most difficult ones to be settled in the model law. It is also submitted that the pertinent provisions to be drafted will have a decisive influence on the value of the model law as a legal regime exclusively geared to international arbitrators. Well, this is where, my Lord, possibly, this is my personal feeling, we have missed in 1996. The discussion was to bring in committee amongst domestic laws, but this discussion was focused more on international commercial arbitrations, not domestic arbitrations. But be that as it may, we go by this. This is particularly true with regard to the grounds on which an application for setting aside an annulment of an award may be based. To some extent, it is also true that regard to the procedures envisaged under domestic laws, to start with the minor problem, that is the procedure, there is a great variety in national laws of different claims for attacking an award. It should be challenging an award. Not only for setting aside or sometimes treated separately annulment of the award, but also to other aims, that is suspension or reinstitution. The disparities extend to procedural particulars such as form, time limits, and competent authority. For the sake of uniformity, which would facilitate international practice as regards post-award stage, an attempt should be made to establish commonly acceptable procedures, in particular to provide for only one type of application and proceedings, probably to be called setting aside proceedings. This is where the first emphasis on setting aside comes. Lord, 109, your Lordships can skip. 110. Ideally, one should aim at a list shorter than the one set forth in 1966 Strasbourg Uniform Law that would contain only those reasons on which recognition and enforcement may be refused under the New York Convention, which I read, my Lord. This restrictive approach adopted in Article 9 of 61 European Convention for enforcement purposes would meet the concerns underlying the corresponding proposal of the International Chamber of Commerce, which is contained in the list of subject matters for possible inclusion in the future work program considered by the Commission at its 11th session. It would help to prevent that an international award falls victim to local particularities of law, although the cases at hand bears no substantive connection with that respective state. Rest your Lordships can, my Lord, consider skipping. Please come to, my Lord, now page 522 at 556. My Lord, this is the third session of the working group of UNCITRAL. My Lord, it starts at 522, but 556 is, my Lord, the relevant part. Now, my Lord, it starts getting in shape, that what would be the shape. But your Lordship would find Roman 6, means of recourse. Your Lordship gets, my Lord?
Yes.
My Lord Justice going against it. Appeal against arbitral award. Question number 1. Should the model law recognize any agreement by the parties that the arbitration award may be appealed before another arbitral tribunal? We are not concerned. This is for two-tier arbitration, but not relevant. Question number 2. Should the model law allow any appeal to a court for review of the award on merits, apart from setting aside procedure considered in question 6.6? Please see 108. Divergent views were expressed as to whether this policy should be stated in the model law. The prevailing view was not to incorporate a provision to that effect. While the model law itself would then not contribute to unification, the hope was expressed that the above-mentioned trend would continue. Another view was that the model law should expressly exclude any court review of awards on the merits in order to further the above policy. A suggestion was made to consider including a provision according to which an award was final or had the effect of res judicata subject to certain conditions. For example, it was not contrary to ordre public. That is, my lord, I read as public policy. Lord, this is all that is relevant in this group, my lord, meeting. Then we come to fourth session, my lord, which starts at page 558. Your lordships may come to 560. Lord, I am leaving those parts which are not relevant for answering the present question. Page 560, my lord. Consideration of possible features of a draft model law on international commercial arbitration.
Yes.
Para 13. The working group decided to commence its work by considering the 4 questions prepared by the Secretariat which had not been discussed at the third session. Means of recourse, setting aside or annulment of award, and similar procedure. Question 6.6. Should the model law provide for only one type of action of attacking an award, that is, setting aside? Leaving aside here recourse against executor, that is for enforcement. But see question number 6 and 8. There was general agreement that the model law should streamline the various types of recourses against an arbitral award and should provide for only one type of action of attacking an award. However, it was observed that the acceptability of this approach may depend on the decision as to which arbitral award was were international and therefore subject to this law, and that the position on this question may not be final. 6 to 7. If so, on what grounds should such an action be successful? For example, would it be acceptable to restrict the grounds to those listed in Article 5, Para 1A, and 2B of 1958 New York Convention, which I read, with a possible restriction of public policy ground to international public policy? This was suggested, not accepted eventually. There was a general agreement that a restrictive approach in listing the grounds for the setting aside of award should be adopted. Some doubt was expressed as to whether the reasons for setting aside needed to be restricted to those which are mentioned in 1958 New York Convention. However, the prevailing view was that the grounds for setting aside should be restricted to those listed in Article 5, Para 1AD and 2B of that convention. Then your lordships can skip, my lord, the rest.
Yeah, this is all on the foreign-seated international commercial arbitration.
International commercial arbitration.
It eventually became a part of a model law which was open for every country to adopt, and with these logic and these reasonings, our country adopted. My lord, I'm reaching to that. It is, if I can say, bodily lifted, my lord. So therefore, this would be.
1961 itself, we had a Foreign Awards Recognition and Enforcement Act.
Yes, your lordships are right.
But we, today in part 1 in 34, the issue that is being referred, whether there could be a modification, severance, how much of profit do you derive from these discussions?
My lord, all of this, when your lordship reaches Article 34 of UNCITRAL, which is bodily lifted in our section 34, word by word. Therefore, your lordships would get assistance what each word meant when Article 34 of UNCITRAL was drafted. Lord, now please come to the fifth session. It starts at page 593, but I'm directly going to 623.
623.
623, my lords. Lord, which eventually became Article 34, was first draft Article 40, like, my lord, we see in the Constituent Assembly debates. This is, my lord, 623, recourse against arbitral award, Article 40. No recourse against an arbitral award made under this law whether or not rendered in the territory of this state. But every state will have to fill up their name. May be made to a court except an action for setting aside in accordance with the provisions of Article 41. My lord, this is Section 5 of our Act, my lord. Kindly note this at this stage. My lord, our law, my lord, now says that except as provided under the Indian Arbitration and Conciliation Act, there will be no other recourse. Meaning thereby 34 is exclusive if you want to challenge. Now kindly come to the next page, Article 41. My lord, this is the present day Section 34 and present day Article 34 of UNCITRAL. The predecessor of, my lord, with modifications. An action for setting aside an arbitral award referred to in Article 40 may be brought before the court specified in Article 5 within 4 months from the date on which the party bringing that action has received the award in accordance with Article so-and-so. An arbitral award may be set aside only on one of the grounds on which recognition or enforcement may be refused under Article 37, para 1A, B, C, D, or 2, or on which an arbitrator may be challenged under Article 9(2). My lord, this again, or incorporation by reference, this New York Convention. The court may, where appropriate, please mark, set aside only a part of the award, provided that this part can be separated from the other parts of the award. But this is the minimalistic interference, that you can set aside either wholly or in part. Severability, but you can set aside. No modification up to here, my lord, that is the position. If the court sets aside the award, it may order that the arbitration proceedings continue for retrial of the case. Please mark the word continue. So meaning thereby, my lord, it contemplated a situation where the arbitral tribunal was not functus officio as yet. So it would continue. We have said resume. Nothing turns on that, but that is the distinction. Unless such measure is incompatible with a ground on which the award is set aside. Suppose bias of an arbitrator. But obviously, it can't be remitted back. But subsection 4 is with a modified form, our section 34(4). Power of remittance, not modification. Remitting back, power of remanding. Any decision by the court on an action for setting aside is subject to appeal within 3 months. Now, my lord, rest is not relevant. Now, please come to, my lord, the 6th session at page 663. It's 663, my lord, your lordship gets, my lord.
Yes.
An award made under this law may be set aside whether in whole or in part. So first, only power of setting aside, whole or part, on grounds on which the recognition and enforcement may be refused under Article so-and-so, on which an arbitrator may be challenged under Article so-and-so, my lord, the New York Convention. An application stroke action for setting aside may not be brought after 4 months. That's limitation. We are not concerned. Come to 3, my lord. This is like our 4, 34(4). The court, when asked to set aside an award, may also order, where appropriate, and if so requested by a party, that the arbitral proceedings be continued. Depending upon the reason for setting aside, procedural defect found by the court, this order may specify the matters to be considered by the arbitral tribunal and may contain other instructions concerning the composition of the arbitral tribunal or the conduct of the arbitral proceedings. A suggestion was made to widen the supervisory power of the court under Article 30 by adding to the list of grounds manifest injustice. What we, my lord, call manifest arbitrariness. Here, manifest injustice. However, this suggestion was not adopted since it was considered as too vague and too broad, and since most cases of such injustice would fall under the grounds listed in paragraph 1B and 2 of article so-and-so referred to in the article. The working group adopted the grounds as listed in para 1 of article 30, which corresponds to the reasons for refusal of recognition and enforcement under 1958 New York Convention. It was noted that the ground placed between square brackets was not needed if the working group would adopt the second alternative in so-and-so. Then come to para 3.
Where will we find this Article 27, paragraphs 1B and 2?
That is the New York Convention. Just a minute, no, Lordship may give me a minute. Article, which article, your Lordships?
27. What is extracted there in para 1?
Page 659, my lord.
Page
560.
659.
6.
Article 27, my lords. This is what your Lordships, my lord, desired to see. These are the grounds for setting aside. No, I'm sorry, these are the grounds for recognition under the New York Convention. They are adopted as grounds for setting aside.
Yes.
Very similar at one point.
Under our law, 34 provides for annulment. 48 provides for grounds on which a foreign award can be refused to be enforced. They were similar, my lord, till, my lord, our jurisprudence developed. My lord, may I read this, or, my lord,
Yes. Please continue.
Article 27, shall I read?
Let's look at this. No difference.
Your Lordship says. Lord, kindly come back to 664, paragraph 154. Divergent views were expressed as to whether para 3 should be retained. Under one view, the draft provision was useful in that it provided some guidance on procedural questions which were relevant in the case of remission. Under another view, the provision should be deleted since remission was not known in all legal systems, and in particular, the idea of orders or instructions to an arbitral tribunal was not acceptable. There should not be any remittance, which we have retained in 34(4). Under yet another view, the option of remission should be retained without the giving of orders or instructions as envisaged in the second sentence. It was stated in support that this device would allow, please mark, my lord, to cure a procedural defect without having to vacate the award. This is how it was intended, the remission for some procedural defect. Procedural defect, my lord, according to me, would mean, I'm sorry, my lord, 34, one of the ground is the party to the arbitration was not given sufficient notice. Procedural defect. One document as an evidence was taken by the arbitral tribunal behind the back of another party, and he didn't have an opportunity to meet with. Procedural defect. But again, remittance on merits was neither envisaged then nor envisaged now. I'll come to that, my lord, when I reach our section 34. Now, my lord, kindly come to page 688 at 717. This is 7th session. Seven one seven. Your Lordships would find I have substantially curtailed, my lord, this thick volume, my lord. I am reading only that part which is relevant, my lord, but I must place, my lord, the entire thing. Now it becomes Article 34. This is for the first time. It gets the shape. Application for setting aside as exclusive recourse against arbitral award. The recourse to a court against an arbitral award made in the territory of the state under this law, this was the name to be filled by each country, may be made only by an application for setting aside in accordance with paragraph 2 and 3 of this article. An arbitral award may be set aside by the court specified in Article 6 only if, these are the grounds which are by and large similar to eventually what became Article 34. Therefore, I am not reading it, I'll read the final part. Then 718 sub article 4, which is our 34(4) for remission, which again not required, my lord, to be gone into because your lordships are examining power of the court to modify, not to remit. The court, instead of setting aside the award, may order where appropriate. Well, please mark the word where appropriate. Well, there are some judgments of British court which says that considering the nature of the defect which we found, we would not like that it goes before the same tribunal. In some cases, they constituted a fresh tribunal and remitted the matter, but that question is yet not finally decided whether the remission power can be used for creating a new arbitral tribunal for removing the defects. But as the law in India stands, it has to be before the same tribunal, because the word used is directing the tribunal to resume the proceedings. So, meaning thereby, the tribunal is functus officio, remains under a cloud, and is revived for the purpose of issues remitted. The rest, kindly come to now 720. As your lordship gets. As regards paragraph 4, the working group adopted the policy underlying that provision, since remission, though not known in all legal system, could be a useful device for curing procedural defects without having to set aside the award. It was noted that the word, instead of setting aside the award, was too felicitous, since it could be understood as upholding the validity of the award for the time during which the arbitral tribunal deal with the case remitted to it. It was also noted that it was misleading to speak of a continuation of arbitral proceedings, since these were terminated by the final award, and apart from that, regard should be had to the fact that the arbitral tribunal may have to repeat an earlier phase of the proceedings. Therefore, the word resume comes from. Remittance may mean, my lord, that you start de novo. The working group was agreed that the wording set forth above, para 127, would meet those concerns. Lord, then your lordships may, my lord, come to page 930. Lord, this is analytical commentary. Lord, what is what, my lord, I have given in summary, page 14 onwards, my lord, in my written submissions. In the next volume, page 930. I'm not reading it, but substantially, Article 34 of UNCITRAL Model Law is crystallized at this stage, and it, with minor modifications, remained so. Kindly turn over the page, my lord. Your lordships would find ground B sub-Roman 2.
Tushar Mehta, as was pointed out by Brother Vishwanath, if you look at it carefully, just read subsection 1.
Yes.
Article 34, or clause 1 of Article 34.
Recourse to a court against an arbitral award may.
Now pause. In the territory of this state, under this law. So basically, they were, in this stage, UNCITRAL was trying to adopt a universal law for commercial arbitration. That's why the bracketed portion says in the territory of the state. So they wanted to specify in the territory of the state where you will be able to file the petition and which is the law which will be applicable. It is quite, therefore, what it was trying to do was, we may have adopted the UNCITRAL model into our domestic arbitration, but with changes. Because obviously, when we are dealing with domestic law, we are not going to mention the law which will be applicable. Neither are going
We
to
say under this act.
or under this act.
I'll answer it, my lord, in two ways. Your lordships are right. What happens is, this was a model
Now,
law.
but there was issue over there. What was happening is, and it continues to remain under the New York Convention, it continues to remain the same. To file, make an award, the seat of arbitration or the law of arbitration which is applicable, say, is country A. Now you will, under that law, you'll file challenge to that award. A party which is dissatisfied, they file a challenge to that award and may lose. Now the law of res judicata is the original cause of action gets subsumed into the decision of the court. So you cannot sue on the basis of the original cause of action.
In regular courts.
In regular, what happens is the original cause of action no longer survives because what is there is now the adjudication. So what you can enforce today is the order or the decision and not, you can't take recourse to the original cause of action in any other country. So that's done by the recognition part of international awards. But because the international award, once it's recognized, you can't take recourse to the original cause of action. You can't file a civil suit, get an ex parte judgment or anything like that. Or even you can't initiate proceedings. But as far as India, what we are concerned today is far more crucial. It doesn't appear that this convention, if it had been implemented, then the second stage of objections under 48 would have become redundant.
May I answer that question? Lord, please read one again. A recourse to a
No,
court.
but now what is happening is, suppose, say award is made in country A. The party which loses may take recourse to appellate remedy, may not take recourse to appellate remedy. But when the enforcement of the award or execution of the award takes place in country B, because the assets of the losing party or the judgment debtor are in country B, you can take recourse to 48, which is almost pari materia with earlier part of 34.
For the time being, my
Or
lord,
unamended 34.
for the time being, my lord, I'm not responding to some part of it, but Lord, may I answer? How, my lord, I read it, and according to me, my lord, this appears to be the intention after having gone through the entire working group report is, please read one. What is intended? A recourse to a court against an arbitral award made in the territory of India under Indian Arbitration Act may be made only by an application for setting aside in accordance with paragraph 2 and 3 of this article. Kindly pause here for me. Lord, it was open for every country to provide for either domestic arbitration and foreign seated arbitration, or as we say, international commercial arbitration. Lord, for example, in India, part 1 deals with domestic arbitration. Part 2 deals with international commercial arbitration. We have a combined comprehensive legislation, and it says recourse to a court against an arbitration award made in India under the Act may be made only under Section 34. In, for example, Singapore, they have two separate arbitration law. One for domestic arbitrations, another for international arbitrations. We have chosen a model which provides both for domestic as well as international arbitration in one legislative framework. And therefore, my lord, this was intended, I can, my lord, assure your lordships, my lord, this was intended to become a model both for domestic as well as foreign arbitrations. It was open for the respective countries to make suitable modifications depending upon their domestic requirements. And such suitable changes are made by some countries. But we have accepted this both for domestic as well as for foreign international commercial arbitration. And the commentary also, my lord, and the way in which it was, my lord, kindly come to page 931. This may, my lord, answer your lordship's, my lord, concern. Objection reasons also mentions, UNCITRAL.
Yeah, that it is
Yes,
specifically
it-
stated.
It does.
Mr. Rao, who was the secretary at that time, had worked on it as a UNCITRAL model of, they specifically stated at that time, when ordinance came, there were some issues, then I think repeatedly ordinance came, because it had to remain under consideration, there was debate and issues, and then 1996 Act came.
My lord, he wrote a book. I have included extracts from that. He's written a book of the 96 Act. I'll show when my turn comes.
Anyway, my book is ultimately a personal.
We were,
I'm reading
we were part of that growing up years at that time. Far knowing.
sole action for attacking award, paragraph 1. But please come to page 931. Existing national laws provide a variety of actions or remedies available to a party for attacking the award. National laws, not domestic laws they are talking. Often equating arbitral awards with local court decisions, they set very varied and sometimes extremely long periods of time and set forth varied and sometimes long list of ground on which the award may be attacked. Article 34 is designed to ameliorate this situation by providing only one means of recourse, para 1, availing during a fairly short period of time, para 3, and for a rather limited number of paragraphs. So it is a
You're right. To that extent, probably the intent was that you amend the domestic laws
also in tune with this.
so that the challenge is also on limited number
Limited.
of ground and same grounds which are available when you challenge the New York Convention of Law.
Exactly. I'm grateful.
But
then
have we,
next.
have we restricted ourselves to that?
We have. I can't say whether fortunately or unfortunately, but in 96, we were not under any
after 90
obligation not to deviate.
After 96.
Lord, it's evolving. I can say, my lord, it's evolving, but ultimately, my lord, some way will have to be found. But at the end of my submissions, my lord, the way can be somewhere else, not
So
here.
the idea was that national and international should be the same grounds. So it becomes, the enforcement of the awards becomes easy.
Easier. And, my lord, also incentivizing other jurisdiction parties to come here and arbitrate on the ground that arbitrate award would be final. There would be very limited challenge to it. So your dispute resolution would be faster. Suppose we have 15 grounds or we have 20 grounds, then it might disincentivize others to come. That may be, my lord, perhaps the intention. Please come, my lord, now to para 2. The application for setting aside constitutes the exclusive recourse to a court against the award in the sense that it is the only means for actively attacking the award, that is, initiating proceedings for judicial review. A party retains, of course, the right to defend himself against the award by requesting refusal of recognition of enforcement in proceedings initiated by the other party. Obviously, Article 34(1) does not exclude the right of a party to request any correction or interpretation of the award or making of an additional award under Article 33, our limited, but our Section 33, clerical and mathematical errors. Since such request would be directed to the arbitral tribunal and not to a court.
Just give me the arbitration.
The
Continue.
no, your lordship may see. I would like your lordships to be with me in reading this.
It in fact goes beyond that. Beyond that, it goes also,
I'm saying more.
clause B goes beyond that.
Yes.
It says, if so agreed by the parties, a party which is a notice to the other party may
May
request
request the arbitral tribunal to correct any computation errors any clerical or typographical errors, or any other errors of a similar nature.
And B, if so agreed,
This is Article 33,
that's fine,
B.
that's clause B now.
page 929, my lord.
That's B of section 33. Asking the arbitrator.
If so
to
agreed by a
interpret
party
the-
with notice to the other party may request the tribunal to give an interpretation of a specific point. My lord, 929, this UNCITRAL Article 33 also has that.
Same as that.
Same, 929, my lords. To give an interpretation of a specific point or part of the award.
The notice is earlier.
We have, my lord, done an excellent work of copy pasting, my lord, at that time, my lord. Then, my lord, kindly come to 934. Again, my lord, we are not on remission. My lords are examining modification, but still I may show what they felt. Paragraph 4, which becomes our section 34.4. Envisages a procedure which is similar to the remission known in most common law jurisdiction, though in various forms. Although the procedure is not known in all legal systems, it should prove useful is that it enables the arbitral tribunal to cure a certain defect and thereby save the award from being set aside by the court. So defect, that was the intention. Unlike in some common law jurisdictions, the procedure is not conceived as a separate remedy, but placed in the framework of setting aside proceedings. We have done this, my lord. It's a part of 34, our 34. The court, where appropriate and so requested by a party, would invite the arbitral tribunal whose continuing mandate is thereby confirmed to take appropriate measures for eliminating a certain, please mark, remediable defect, which constitutes a ground for setting aside under paragraph 2. So first it has to be remediable defect. And it should be severable. But my lord, there are judgments where despite the power of remand or remission having been exercised, the tribunal says that no, we uphold our decision. Matter goes back to the court, which we call 34 court. And court said, now we have no other remedy, we set it aside. That's how, my lord, internationally, unless in some countries where they have deviated while making their domestic law to be non-compliant to Article 34. There are countries, as I have said, my lord, United Kingdom, United States, Canada, France. France is, of course, not a signatory to UNCITRAL, but they have a separate mechanism providing for what they call variation in the award. The court has a power to vary the award or modify the award. But otherwise, everywhere, my lord, setting aside means either you set aside or you affirm. Unless you can sever it, then set aside only in part. Now, my lord, please come to, I am coming to an end of this, my lord, page 945. 941, my lord, first. We have India has participated in this debate, 941. Para 8. Article 5, Lord, kindly give me a little, allow me to have a preface. Article 5 is our section 5, which says that no recourse against an award except as provided in this act. My lord, section 5, it's a 2-line section. Notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, that is part 1, domestic arbitration, no judicial authority shall intervene except where so provided in this part. Now that is Article 5 of UNCITRAL also. Now, my lord, in this context, please read para 8. The United Kingdom had dwelt on the difficulties which might arise in deciding how to read Article 5 in a situation concerning which nothing was found in the model law. There might, of course, be nothing in the model law about a specific situation, but in that case, it would be necessary to look at the provisions of the model law dealing with the area out of which the situation had arisen. He agreed that decisions on individual cases would be very difficult to make, but he doubted whether the model law could go beyond using the word in matters governed by this law. He in fact said that don't make it wide, give us a choice. The choice was not restricted or given, but the Britain has used that choice. I'll show my lord the corresponding provision in Britain. United Kingdom's written comments included the question whether it was really the intention of the model law that Article 5 should operate to exclude judicial control in situations not foreseen by the working group on international contract practices. That was obviously not in its intention, because the list of matters which the working group had decided not to deal with in the model law was clearly given by way of an example only. Now, please come to the next page, para 11. Mr. Sekhon, he represented India in this UNCITRAL working group. Mr. Sekhon, India, said that his delegation endorsed the United Kingdom's objection to Article 5, but would not like to see it deleted. It was important that model law should find wide acceptance in different countries. In India, for example, judicial control of arbitration was sometimes exercised by the Supreme Court. In the states, the High Courts under Article 227 exercised superintendence and control over various tribunals, including arbitral tribunals. Those controls should not be removed. His delegation could accept Article 5 if it was modified to enable parties to opt out of it. But I must tell your lordships, at this stage, there is a constitution bench judgment on this point of our court, which takes the view that Article 227 is not permissible. But thereafter, there is a two-judge bench in Deep Industries, my lord, penned by my Lord Justice Nariman, my lord, who has taken the view that for some cases 227 can still be invoked against an arbitral tribunal award. My lord. But we are not concerned with this. This is what was discussed, my lord, in the... now your lordships may kindly come to page 945. Lord, these are various meetings. I'm not giving the name of the meeting, my lord, but 945. The date of the meeting. My lord, date of the meeting is in my note. My lord, I have given the date of the meeting, what happened, and I'm just taking your lordship through the relevant paragraphs.
We have only reached 1985, 11 more years to go.
No, yes, but my lord, there are only 4 pages to go. Those who forget the history are condemned to repeat it. But I don't want to forget the history, because my 34 is based on this discussion. That's the problem. And your lordships must know, my lord, what was intended. Now, my lord, para 4. But we are, my lord, underlying message taken. Underlying message of my Lord Justice Sanjiv Khanna taken. Yes. Para 4. Sir Michael Mustill, United Kingdom, expressed concerns that the exclusive list of grounds for setting aside an award would not cover all cases of procedural injustice. In its written comments reproduced at so-and-so, his government had given some examples of that. The concept of public policy mentioned in para 5, para 2b2 did not exist in his country, and he could not say whether in other countries it would cover the examples he had mentioned. His delegation would welcome the addition to the article of a more general formula to ensure the possibility of recourse in all cases of serious procedural injustice. Now, 7 is India's 10. Mr. Sekhon agreed with the United Kingdom representative that the grounds given in Article 34(2) did not cover all possible cases. The Commission might, for instance, wish to include a provision covering misconduct of the arbitrator. If so, he would suggest suitable wording from his country's Arbitration Act. 1948 was the act in force. The question of public policy was a delicate one. It might, for example, be the public policy of a state with a considerable foreign debt to prohibit payments from being made to creditors in foreign countries, including payments owed under international commercial arbitration awards, etc. But, my lord, this was just a suggestion and nothing, my lord, happened thereafter. Please come to 949. First, my lord, 948, my lord. It would be necessary, my lord, Hungary, because we accepted what Hungary said. India agreed to that. But 948, your lordships can skip, my lord, nothing may perhaps turn. But 949, right side column, Mr. Second, para 34. Lordship gets, my lord. Para 34, 2B, para 34, where they discuss Article 34, 2B, Roman 2. Mr. Sekho stated that his delegation would prefer to see paragraph B2 deleted. Now, B2 was public policy. Your lordships can mark page 930 is that B2, my lord. Page 930. The expression public policy was much too vague and had very little to do with the law of arbitration. My lord, this was really correct. Public arbitration is a contractual dispute, my lord. There may be minimum existence of a public policy, except, my lord, in some rare cases. If the subparagraph was retained, the Commission should consider deleting the phrase or any decision contained therein, which was superfluous, as whole necessarily included all of its part, and the decision was part of an award. Now, your lordships may come to 953. Now, my lord, I am quickly coming at the end. 953, para 5. Mr. Second said, your lordship gets, my lord, that his delegation was in favor of paragraph 4, which is our 34(4), which is power of remission. The fact that such a provision was not found in some legal systems was not a reason for excluding it if it was meritorious. The aim, after all, was to harmonization of law. It was not, it was domestic law harmonizing at the global level. It's very clear throughout. He suggested that the words "an opportunity to resume the arbitral proceedings" should be replaced by the word "an opportunity to reconsider the arbitral proceedings." Not accepted either by UNCITRAL or by our parliament. We continued with resume. Now kindly come to page 958. At 1016. Just let's put final. So this is where Article 34, as it became a model law, took the final shape. There is no change thereafter. They have also gone into corruption, etc., which maybe, but that is ground of public policy, they have said. But right now, though it is a very serious ground and a serious concern of everyone involved, but may not be relevant, for the answering the present question. 1016, your lordship gets, Recourse to a court against an arbitral award made in the territory of this state under this law may be made only by an application for setting aside in accordance with para 2 and 3. So, linguistically, purposive interpretation, whichever means of interpretation we may employ, as the law stands, which we have adopted, is the power to set aside. Set aside can be either whole or in part, if there is separable, but power to set aside. And I'll show, my lord, the countries which have not accepted this model, they have provided for the power of modification and variation. Now, your lordships may, my lord, kindly see 1022. paragraph 4. So this is again remittance. Remittance, we are really not concerned. Power of remit.
The point of having power of remittance, then they can also do it.
Lord, one more aspect, Manan, can you bear this in mind?
Yes,
But if we read power of modification or power of varying the award in section 34, then my lord, subsection 4 becomes meaningless. Why remit it? If you find there is something wrong, modify it. But because it only permits setting aside, there is a provision that rather than setting aside, to save it being set aside, let us give an opportunity to rectify curable defects. Lord, the very fact to the arbitral tribunal, the very fact that there exists subsection 4, which provides for remitting, which, my lord, says that rather than setting aside, we would rather give an opportunity to the tribunal to correct if some of the defects can be cured. My lord, very existence of 4 would nullify, my lord, any reading of modification power or varying power in 34. My lord, now, my lord, come back to the note. My lord, this is over, my lord. We accept it.
While the first part of your argument can be appreciated, that setting aside in the context, the way UNCITRAL proceedings had gone about and with the idea to have uniformity. To say that only on the basis of subsection 4, power to vary cannot be exercised may be slightly difficult
Not only,
because that's its separate part.
it's a separate argument that
That's
the
a
very
separate-
existence of
Mainly
4.
because you have one recourse or remedy available.
You may choose another lesser. But I can understand, my lord, if your lordship.
You may have two or multiple concurrent remedies available in a given case. Mainly because implied bar can argue based upon the power of setting aside, which doesn't use the word vary or modify, along with 34(4). You can argue together, there's an implied bar, therefore for the court to modify or vary the award.
Well, I bow down, my lord, there is no difficulty about it.
But
as the
only
way
on
I see-
four, you can't rely.
Lord, I wish your lordship finds a power of modification in 34, but it appears to be very difficult to find one. For the reason that subsection 5 says that except provided under the Act, there is no remedy. What is provided is 34, which is power of setting aside. And 4 provides that because we can only set aside, rather we remit. And that's how, my lord, that subsection 4, wherever it existed, is understood by all jurisdictions. That since the harshest and the only remedy is to set aside, 4 is a lesser remedy. What possibly, my lord, the Chief Justice says is that there may be a power of modification, but the court in a given set of facts may feel that rather than my exercising the power of modification and varying the award, I may send it back on a particular issue if there is a curable defect. They eventually did not follow model law. The rest of the country, rest of the world, my lord, followed model law. Most of the countries have followed model law. Lord, kindly see 34. An application for setting aside arbitral award. Recourse to a court against an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 and subsection 3. So the only prayer one can make is that set it aside. There is no other prayer permissible. Either we go by the literal interpretation or any other interpretation. Now please see 2. An arbitral award may be set aside. Again, my lord, set aside by the court only if the party making the application establishes on the basis of the record of the arbitral tribunal that ABCD I'll come to little later, but unless the party requesting for setting aside satisfies, there is a finality attached under our scheme to the award. Now, my lord, kindly for the time being skip to the grounds on which it can be set aside. My lord, come to 3. My lord, 3 is limitation, come to 4. My lord, limitation we are not concerned. 4. On receipt of an application under subsection 1, that is requesting that you please set aside on these grounds, the court may, where it is appropriate, and it is so requested by a party, adjourn the proceedings for a period of time determined by it in order to give the arbitral tribunal an opportunity to resume arbitral proceedings or to take such other action as, in the opinion of the arbitral tribunal, please mark, will eliminate the grounds for setting aside the arbitral award. So if they do not do that, the only consequence would be setting aside. Now, having seen this, please read grounds of setting aside. 2, subsection 2.
The language used is very careful, very carefully selected. Eliminate the grounds. It
Yes.
doesn't talk about grounds to set aside the award. It says eliminate the grounds.
Eliminate the ground.
So final adjudication at that stage may not be required. That the grounds for setting aside of the arbitral award have merit. Says eliminate the ground, because eliminate the ground.
Otherwise, we'll have to set aside. You eliminate it, otherwise the grounds are such that we'll have to set aside.
There are 2 ways to interpret it. Eliminate the grounds for setting aside of the award. Eliminate the grounds means to eliminate the grounds which are raised by the party raising objections. 1, maybe examining them prima facie. 2 is the second stage where you don't examine it prima facie. You come to the conclusion, yes, these grounds have actually substantial merit and the award is liable to be set aside. But I will not set it aside. I'll give an opportunity to the tribunal to rectify.
Because I can only otherwise set aside.
No, there are 2 ways to do it. One is what is the level of the opinion formed by the court? The question is, what is the level of the opinion formed by the court under subsection 4 when it excises, when it will exercise its jurisdiction?
It can't be prima facie. It can't be prima facie.
According to you, it will be when the court forms a firm conclusion?
Yes, my lord. And if we read, my lord, the way, my lord, it is suggested, then why not set aside?
Now, if we do that, if we accept that argument, it will mean virtually your court has to then record reasons why it's setting aside the award and then saying, I'm making an order or remit.
It will have to. Okay, it will have to. It can't be remand simpliciter. There are
So
some.
upon the request of a party.
And it
Section
says,
4 says it is upon the request of the party that the court will remit it,
Yes, ma'am.
not automatically. The request must also come from the party.
Correct, my lord, correct. My lord, request means,
Solicitor, just
my lord,
keep this, solicitor,
my lord,
solicitor.
my lord,
Who will normally make the request?
the aggrieved party,
Party who.
losing party.
Party who has succeeded, because he will say predominantly, for heaven's sake, don't set aside-
Lordships are right, that otherwise
don't
my,
set aside the award, some document not supplied, just get that without upsetting the reasoning, just get that sorted out, because the party who's filed the application wants a complete setting aside of the award.
correct. It would be used by the respondent.
Respondent invariably, unless the party is clear to the party that, look, the award is not going to be set aside in full, let me at least salvage.
In some cases, yes.
So, invariably by the respondent. Now, suppose in matters of interest, etc., unless the court expresses a view.
Severable. It can be, my lord, the interest can be immediately.
To what extent? Substitution is also severance. Can 16% be made 12?
You are partly setting it aside.
You don't have to resort to 34.
No, please have a look at 4 again, my lord. Can I read 4 again?
Yeah.
Please read it with me, my lord. 4. On receipt of an application under subsection 1.
Subsection 1, application is by the party
By the
which is
party who is losing.
objecting to the award.
Award. So, and subsection 1 provides that request for setting aside. So, only remedy and the only prayer before the court would be to set aside. The court may, where it is appropriate. So, as I have said, my lord, appropriate would mean that court may say that sending it before the same tribunal may perhaps not be appropriate. I may rather examine it. And it is so requested by a party, adjourn the proceedings for a period of time determined by it in order to give the arbitral tribunal an opportunity to resume the arbitral proceedings or to take such other action as in the opinion of the tribunal will eliminate the grounds for setting aside the award. So it will have to
will eliminate, will mean the ground which is raised but not final, which ground which is raised by a party, but without forming a firm conclusion, or only after forming a firm conclusion that.
Would your lordships now come to subsection 2? Because these are the grounds which are to be eliminated.
Is there any direct decision of this court on that? No.
No.
34.4 or if on the conclusion.
Dyna, which is I pay doesn't follow.
There is.
I pay, my lord, Justice Reddy's judgment.
You also.
Where Dyna is considered, my lord, not followed, but considered. I am coming to that. That is a part of my submission. My lord, kindly see, my lord, now the grounds which are the defects which can be cured under 4. 1A1, 2A1. The party was under some incapacity. Lord, meaning thereby suppose the one of the party was a minor. So there is no question of sending it back because this is not a curable defect. Arbitration between, Lord, am I with your lordships? Arbitration agreement is not valid under the law to which the parties have subjected it, or failing any indication thereon under the law for the time being in force. Again, my lord, it can be remitted because the court will have to at least prima facie form an opinion that arbitration agreement is not valid arbitration.
Arbitrator cannot make the arbitration agreement valid, so it cannot be done.
Correct. So, my lord, this is not a defect which is, I would say, curable under 4. Then 3, the party making the application was not given proper notice of the appointment of an arbitrator or of the arbitral proceedings, or was otherwise unable to present his case. But for 4, the only remedy was to set aside. Therefore, 4 says,
No. 3, last part is very important. Or was otherwise unable to present
his case.
This will be the most resorted to.
Correct.
We'll find a similar phrase in part 2 also.
Correct. So,
Natural justice part.
Like, my lord, I as a respondent give some document behind the back of the petition.
Yes.
Or some argument made behind my back and I was not given an opportunity to meet with that. So that this is curable. But why? Because otherwise, but for this curing, I will have to set it aside. So better I remit it. That's, my lord. In my reading, my lord, I wish your lordship finds out a way. I wish a judicial supervision on arbitral proceedings, because complete needle of the eye test has created more problems than, my lord, what was intended by restricting the challenges. And all of us will agree on that, my lord, on all sides, my lord, because we have suffered, my lord, awards several times. The arbitral, then 4, the arbitral award deals with a dispute not contemplated by or not falling within the terms of submission to arbitration, or it contains decisions on matters beyond the scope of the submission to arbitration.
Well, 4 apply in
This can,
Roman 4 also, situations covered by Roman 4, subsection 4.
Their severability is provided. But court will have to prima
Now, suppose it's not possible for a court to sever it because of the way the award
then
is
set aside.
Can you resort to subsection 4 to deal with the infirmity created
Cannot.
by 4?
Cannot be. For two reasons it cannot be. My lord, one, if it is not severable, there is no question, my lord, because proviso, kindly read the proviso. Provided that if the decisions on matters submitted to arbitration can be separated from those not so submitted, only that part of the arbitral award which contains decision on matters not submitted may be.
No. This doesn't deal with the power of the tribunal. This deals with the power of the court.
Correct, my lord.
This does not deal with the power of.
No.
No, one minute. This deals with the power of the court to set aside the award or partially set aside the award. But it doesn't curtail the power of the court or contain the powers of the court under subsection 4. Say, in a given case, arbitral award combines two claims together and passes an award clubbing them and says both the claims are overlapping. And that they can be various situations. We can't visualize all situations.
You cannot do.
But the court then feels this part of the award, this part is not covered by the arbitration clause. And wrongly it was held by the tribunal, it's covered by the arbitration clause. Because validity or existence of the disputes covered by the arbitration clause is a complete review. It's a complete review. It's a pure review by the court. It's not a
Permissible.
It's a permissible complete review.
Impermissible review.
No. Whether a dispute is covered by the arbitration clause is a complete review.
Yes.
By the court under the review. It's not restricted by any other.
34(2) or other
Yes.
restrictive provision.
It's a complete. Existence of the arbitration clause, its second look is complete. Unlike when so many times when lawyers come and argue, they say it's not going to be complete. I've seen even over here, sitting with my brother once or twice, it's a complete review. It's not a half review. Or whether the dispute is covered by the arbitration clause, it's a complete review. But if therefore, when you say, you feel I have to set aside the award on that, can you not pass an order to remit under subsection 4, segregate that part?
You can remit, but there is no difficulty about it. My emphasis is not that there is no power of remitting. My emphasis is the power of remitting exists because there is no other power other than setting aside. So you save it if you can save it, because rather than setting it aside, resort to a lesser, if I may say, my lord, the procedure, so that it is saved. Otherwise, I'll have to, as a court, I'll have to set it aside. Then, my lord, C4, 5.
Just 1 minute. Just 1 minute.
But please come to 5. 2.5. The composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of the parties unless such agreement was in conflict with the provisions of this part from which the parties cannot derogate, or failing such agreement was not in accordance with this part. But if suppose the court comes to this conclusion, then there is no question of remedy. Because the very foundation goes. The composition of the tribunal itself is in question. Then the remedy would be setting it aside. Then D, the court finds that the subject matter of the dispute is not capable of settlement by arbitration under the law. But again, remitting will not help. If this is a conclusion, then award will have to be set aside. I wish your lordship finds, my lord, some power of modification, but the moment, my lord, I will show other jurisdictions which have not followed 34 to the hilt, and they have tailor-made their, my lord, statutory provisions based upon their domestic situations. They have specifically provided for the power. That's the problem. I am not arguing that it has to be set aside. The law as it stands only empowers setting aside.
Solicitor, you will also address us on the scope of the phrase set aside, modify, because reversal is not modification. A claim can't be, a rejected claim can't be awarded. That will be reversal. One of the claims in Gayatri Baluswamy, there was a setting aside and a reversal. That can't be done. But set aside, is it not a word of wide import?
Wide magnitude.
Modify also. Our commonly understood notions of modification we keep aside. And you look at some words and phrases, modify without altering the basic structure. Suppose of the awards. Suppose there is a setting aside in the broad sense. Interest chopped off from 16 to 12 in the interest of justice.
But the word setting, that phrase setting aside, is used in a particular context in the model law, which also means annulment and vacatur. Setting aside has a particular.
Is it only that? Is it the binary of setting?
That's the only interpretation.
My lord, that word,
Intended.
that phrase setting aside, my lord, has a particular meaning. We'll show, my lord, what is that meaning of that phrase. One
Then
argument.
you are adding the word wholly set aside.
My lord,
Set aside.
it also, my lord, set aside in whole or in part is also a part of annulment. You can always set aside a part, but whether in.
The setting aside of a part is only confined to a particular circumstance covered by 3, covered by 4. It is not possible.
Severability. and
Severability is only covered by 4.
If contingency.
Correct. But in a given situation, just like normally, where do we get into difficulty? Let me put it very clearly, where do we get into difficulty? One case is obviously the interest part. So its irony is now gradually we are coming down to mandatory rate of interest.
Mandatory?
Rate of interest being
Yes.
specified. We gradually come into the, if we go by MSME Act, it's 36%.
No, this is against public policy. My lord, we can virtually argue. Someone can argue.
Anyway, but we are gradually going to mandatory rate of interest. But there's another circumstance which we always face. We find that the arbitrator has awarded, say, damages, but it twice over. That's normally a problem.
But one thing on,
Then
That's a major problem. Where what happens is you award it, say, for ideal labor, and at the same time you award it for the bank interest.
correct. Lord, my answer is this.
Then
If it-
it becomes, you want to, then at that time, it's not covered by the arbitration clause. It's not an issue which is non-arbitrable.
May I answer?
Clearly, you feel there's overlapping. There's a clearly overlapping which is taking place.
Lord, answer is this.
That's
Only a minute.
normally
Mr.
the
Das,
situation.
answer.
Sorry.
Let me answer.
Okay, fine.
Let me answer.
I wanted to show Article 36 of UNCITRAL Model Law. The grounds to set aside the award are identical with the grounds not to enforce the award. And there is a commentary in the United Nations why the ground to set aside the award. Because what happens in 34, the award is international commercial. One of the country's participant can set it aside in his native
Right.
country.
That
Those are the
was
grounds.
Right.
Otherwise,
The UNCITRAL-
enforcement,
The UNCITRAL framed it, they were catering to all countries.
exactly. And what they say is,
What could be part one in one country could be part two in another.
Yes.
They had to formulate something
Yes.
uniform.
No, therefore,
I'm
we will
on a-
not
I'm
get
on a-
any
I'm on a
assistance
slightly
from
different point.
articles or commentaries.
no, I'm on a
That's the
different point.
difficulty.
1 minute, I'm on a
Because
different
every
point.
author has written commentary based on his domestic.
No, one minute,
situation.
1 minute. In the commentary, they say, how come you have kept the same terms and conditions for refusing to enforce the award vis-a-vis setting aside the award? So they say the ground for setting aside are the same because if the award is set aside, like annulled, it also can't be enforced. So even if I don't challenge it,
Correct, correct.
I come for enforcement. There also I can. So that's very
No.
important.
So
And
the
the commentary
award
not-
must be, award, if it is set aside in the country where where the law of arbitration is applicable to that situation
The agree party.
by, then obviously it cannot be enforced.
No, no, no.
There are laws.
There's a very important point because for annulment,
Some
Lord, I'll
cases
just
where
answer that question, my lord.
award set aside in France, enforced in England.
yes,
Award set aside in
Russia, UCOS,
America, etc.
UCOS award.
Your lordship is thinking of the Putra Bali case.
Bali or
At its seat, set aside, but enforced in
See, the whole difficulty is that, that's why when just Mr. Chandrasekhar Rao in his book, he says, we wanted to adopt 34 after making proper modifications.
Books, my lord, I
No
don't think can
modification was
assist
made.
or lead us
The
anywhere.
tragedy was no modification was made to 34. Everything was copy pasted.
and
That was the problem.
awards upheld.
But
not
then the
enforced.
solution is the
Awards
same
upheld.
place where the mistake occurred. That's
No.
the argument.
No, that is called delocalization, where the award is upheld in Russia, but another country can refuse. That Sundaresh Menon's lecture is there as to when delocalization can be done.
We rely on lectures and articles.
That is Jada case.
Dallas case.
That is.
But that's not different. My only point was 34 was adopted verbatim. Intention was to make proper modification. It was not done. So it's really a square peg in a
That's
round hole.
exactly that
which
it
we are
needs to be
suffering
done
now.
legislatively. That's what, you can't read it. But the answer to my lord's very pertinent concern, that suppose there is a double damage is awarded. But the answer is simple. If it is severable, that part will have to be and can be. Only a minute.
Under which section? In which part will?
Four
Four, see, look at four.
deals with a dispute not, or my lord, public policy or patent
No,
illegality.
no, but for public policy, the proviso doesn't apply.
The patent,
Until unless we read setting aside will include partial setting aside.
my lord, question, answer
And
is.
that partial public.
My lord, let me put it, my lord, as clearly as possible. The example given by your lordships may be a good justification for power of modification,
But then say it cannot be modified.
cannot be modified. It has to be set aside.
It has to be said.
Set aside.
Then argue, don't say partially.
Yes, yes. My lord, justification does not confer jurisdiction. There may be cases where there is a justification, and I, my lord, agree. How do we? My lord, all of us agree. There is a need. We are only arguing, can we find? I'm sorry, but I missed something interesting, my lord, which we are supposed to miss. Well, all of us agree that there needs to be a judicial supervision, intervention, whichever form, my lord, over and above, my lord, 34, which would be in furtherance of and in the interest of the arbitration in general. We are just, my lord, examining and assisting your lordships whether the law as it stands permits that. Without reading into it, supplementing words, legislature can do it. As a matter of fact, one committee, my lord, where the only domain expert was my learned friend, recommended modification.
Okay, now let me come back to subsection.
Actually, what the learned Chief Justice said can come under basic notions of justice. Because nobody would, no justice would warrant a double award.
Correct.
So let's give a,
Then remedy,
so let's say a given case where the
partly
arbitrator,
set aside, yes.
where the arbitrator has taken a particular clause as liquidated damages.
73, 74,
Because these are normal, they take it as liquidated damages, 20,000 or 50,000 rupees a day. He holds, you feel when you read the award, you come to the conclusion, yes, there is a breach. Damages have to be awarded, but this is penalty, not liquidated damage. Can you take resort to 4?
No, it would perhaps be patent illegal. That's how the patent
Can you
illegal.
take resort to 4? Section 4.
My lord, as of now, no. Diana doesn't say so, doesn't permit that. But iPad is as diluted dilemma, my lord, whether it. And I think, my lord, my respectful view is that the next judgment is, my lord, a little more sound on this principle. IPAC. I'll, my lord, cite few paragraphs from Diana and IPAC both. My lord. This is dealt with. Jurisdiction. My friend is right. Your lordships have given 1 or 3 examples, but there can be many examples.
So I'm just giving examples which normally
Yes, yes,
occur
where
when we
modification is
confronted
needed.
with that situation, whether
nobody's-
instead of setting aside the award, sometimes feel, okay, we know this is the damages, this is a penalty clause,
Lord,
penalty into it.
visualize a situation. Your lordships, in a 5-judge combination decides and empowers section 4, that is 34 court, subsection 4.
Why will you do it?
All section 34 courts in India, Lord, where 34.
So that's equally as far as interest is concerned. Again, interest, when we reduce the rate of interest or enhance the rate of interest.
Unless before your lordships under 142, that is what is done in past,
No, 142 is something different.
but not by the district court or the high court. My answer in law is clear. Not that that is a good thing to do. There needs, my lord, a change. The question is whether the law as it stands permit. Lord, otherwise, my lord, the 34 proceedings go before district courts, high courts, and eventually before your lordship. But the first court of first instance would be district court and high courts. Lord, it might be counterproductive, my lord, to split subsection 4 and read something into it so as to permit, my lord, either modification or remitting beyond the scope which is intended.
No, we are not going by that. We go by the term, we give an expansive meaning to the term, setting aside to subsume in it a lower.
Lord, that is a part of my written submission. But it does the larger involves the smaller, includes the smaller, but larger includes the smaller of the same genre.
If we can knock off and annul the award, why not partially annul it?
Your lordships can. But your lordships for modification.
That power of the Chief Justice said should inhere, because what it does is effectuates the final power. And
There are 2 answers. There are 2 answers. Lord, setting aside in part may include, I'm sorry. Setting aside may include and will include setting aside in part. That is annulment in part, not modification.
Rewriting. Modification practically amounts to rewriting.
Rewriting.
That power will you say is part of the whole.
Number two, for modifying the 34 court will have to go into the merit review, which is purposefully prohibited.
May not be fully.
It will have to.
Not in all cases.
Not in all cases, but my lord, what about in some cases? But my lord, I don't think, my lord, jurisprudentially, setting aside can include modifying. Setting aside may include setting aside in part.
But when you modify, aren't you setting aside that part? To the extent you modify?
I don't think, my lord, that would be doing violence to the linguistic meaning of the word. And my lord, there are judgments on this.
Why restrict the power of the court?
No, the act, the way it designs and the purpose it seeks to achieve, the purpose is to restrict the power of the court. Minimalistic interference. But it's not, my lord, a good thing to, I'm not, my lord, justifying.
Look, there's one way, that's one way to look at it. The other way to look at it is, it's the objective of every law that the litigation must come to an end.
Well, this will ensure, my lord, it flares up. Kindly see, my lord, the district court, my lord, in some, my lord, most of the states, my lord, irrespective of the pecuniary jurisdiction, 34 goes before a district court or a commercial court. And, my lord, it's a wide open field.
They are equally good, they are very good.
No, I'm not saying the competence level, etc. I'm saying, my lord, the enormity of the problem which will arise throughout the country, where everyone would have its own thinking process, justification, logic, whether I should set aside, I should modify, I should remit, I should vary, I should do it in part. Therefore, my lord, the law is clear. You can set aside or you can remit on the limited grounds mentioned in 4. That's our interpretation. And of course, correction under 30th. Because otherwise, if the modification is read in 34, even at appellate stage, it can be modified.
Yes,
So
certainly.
there has to be. But I'm not saying no. Appeal is a continuation of the original proceedings. If the power is there in the court of first instance, it would continue with the higher appellate court at least. But can I? It's one of. Can I start the at 2 o'clock?
Let us first
or form of being so and so, to make radical changes in, to alter without radical in transformation, to qualify the sense of a word, to change a vowel, etc., etc. They are completely poles apart. Setting aside means it ceases to exist, and modify means it exists in a change format. But modification power is needed. My lord, the respectful submission is that it may perhaps not be possible by an interpretative process. No, my lord, I'll finish, my lord. I have also done something else, my lord. I have just flapped my submissions. Rest I'll, my lord, skip. Your lordships can, my lord, whenever your lordship finds convenient, go through it, my lord. We have collated judgments on each point from various jurisdictions, which would really assist your lordships, but I'll read only one or two. My lord, first kindly come to page 18. My lord, I have already pointed out that UNCITRAL provided for a model law. We are concerned with 34. Lord, these are three examples which I am giving where the respective countries chose not to follow that law, model, and they provided for its own. I'm sorry, my lords are.
Yes.
Page 18. Lord, this is first is England. They didn't follow UNCITRAL model law. And they have, my lord, three provisions, but to understand the first, section 30 would be relevant. My lord, therefore, I have, my lord, Justice Vishwanath.
Yes,
Page 18, my lord.
Yes.
Right side bottom is the paging machine. Yes. Lord, they participated throughout in UNCITRAL proceedings, all these working groups, meetings, etc., but they ultimately did not follow. They were leaders, my lord, Britain and US, but both of them did not follow. My lord, competence of tribunal to rule on its own jurisdiction. Your lordships may not find it relevant as of now, but no, it is relevant. It is relevant, but please read it. Because when I come to the second section,
Where are you reading?
page
The
18,
same written submission.
same written submission.
1/8 is it?
1/8, I'm sorry.
The first one to 80.
No, my lord. I'll not, my lord, I'll skip most of the pages by the time I reach 80, my lord. 1/8. My lord, this is relevant to understand the subsequent article, which empowers the court. Competence of tribunal to rule on its own jurisdiction. Unless otherwise agreed by the parties, the arbitral tribunal may rule on its own substantive jurisdiction. Now, substantive jurisdiction is defined, that is as to whether there is a valid arbitration agreement, whether the tribunal is properly constituted, and what matters have been submitted to arbitration in accordance with the arbitration agreement. Any such ruling may be challenged by any available arbitral process of appeal or review, or in accordance with the provisions of this part. Now, my lord, having this in mind, please see 67. My lord, I also misunderstood substantive jurisdiction to mean something else, but it is defined in section 30. Therefore, I have quoted section 30. Challenging the award, substantive jurisdiction. A party to arbitration, my lord, I am not reading the entire thing. Please come to 3, subsection 3. On an application under this section challenging an award of arbitral tribunal as to its substantive jurisdiction, the court may, by order, confirm the award, vary the award, or set aside the award in whole or in part. Whichever legislature wanted this power to be conferred, it is so conferred specifically, distinguishing it from the power of setting aside. Now, my lord, 68. The court may set aside the award. My lord, this is similar to not peri materia.
Take 34. Similar to 34.
34, yes. Yes. court may set aside the award. My lord, here, these are almost like 34. Almost, I'm not saying, my lord, verbatim same, like other jurisdictions, but the power is only power of setting aside. Now, please see 69. Lord, 69, again, my lord, gives the power of modification. Appeal on a point of law. My lord, kindly come to the next page, page 21, subsection 7. But am I with your lordship, my lord, the Chief Justice? My lord?
I've got it.
7. On an appeal under this section, the court may by order confirm the award, vary the award, remit the award to the tribunal in whole or in part for reconsideration in light of the court's determination, or set aside the award in whole or in part. The court shall not exercise its power to set aside an award in whole or in part unless it is satisfied that it would be inappropriate to remit the matters in question to the tribunal for reconsideration. The respectful submission is that there are three contingencies which empowers the court to do something. First contingency empowers the court to modify, vary, set aside, whole or in part. Second, no such my lord, power being conferred, only power is setting aside. And third, when it is an appeal on a point of law, again, the court will have the power to set aside, power to modify. My lord, then kindly come to page 22. My lord, this is United States, USA. England also made its law in 1996, simultaneously with India. So they also had the advantage of all the discussions. They participated in the discussion before UNCITRAL. They had the advantage of the model law, but they chose to have their tailored statutory mechanism and suitably, my lord, modified for their domestic law. Now, my lord, kindly see section 11 of the United States of America, right at the foot.
Yes.
In either of the following cases, the United States Court, in and for the district wherein the award was made, may make an order modifying or correcting the award upon the application of any party to the arbitration. We are not concerned with the ground. My lord, the purpose is to point out that there is a specific power of modification conferred, but please see now Singapore, my lord. Here, my lord, it is made very specifically clear. Singapore is the only jurisdiction we could find where there is a negative injunction that you have no power of modification. Page 23. Does your lordship get page 23? No judicial review of award. The court does not have jurisdiction to confirm, vary, set aside or remit an award on an arbitration agreement except where so provided in this act, similar to our section 5. Now, my lord, appeal against an award, please turn over to page, my lord, page 24, subsection A. On an appeal under this section, the court may by order confirm the award, vary the award, remit the award to the arbitral tribunal in whole or in part for reconsideration and set aside the award in whole or in part. Now, my lord, kindly see at the foot. Singapore has two laws, one for their domestic arbitration, another for their international arbitration. We have, my lord, a comprehensive scheme, part 1, part 2, but they have put it, my lord, separately. Please, my lord, see page 25, I'm sorry, page 24, model law to have force of law. Yes, ma'am. Subject to this act, the model law, with the exception of chapter 8 of the model law, has the force of law in Singapore. So, my lord, they have, for international, they have adopted the entire UNCITRAL law. Which, my lord, as I have pointed out, my lord, the intent and purpose being culled out from the discussion, does not permit modification. My lord, then Australia also, my lord, your lordships would find page 25, appeal against awards. My lord, this is a full-fledged appeal. What we have is a recourse against the award. This is an appeal, and see subsection 7. My lord, am I with your lordships, my lord? Or I am, my lord?
On determination, on the
Yes.
determination.
On the determination of an appeal under this section, the court may by order confirm the award or vary the award or remit the award or set aside the award in whole or in part. Look, this is 2017 enactment. Lord, similar, I am not, my lord, duplicating it, but my lord, your lordships would find at page 28 Canada, section 45, at 27, my lord, page 27. The court may confirm, vary, or set aside the award. Look, these words in the international jurisprudence of arbitration have separate, different, and distinct connotation. And whenever, whatever power is sought to be conferred or intended to be conferred by the legislature has used the word accordingly, like in Britain. In one case, permissible, second case, not permissible, third case, permissible. Lord, I am not duplicating, my lord, I have given it for,
I understood this part of the argument.
my lord,
We have
15
understood that other legislations as well as draft legislation made a deliberate change
yes,
compared to the other earlier.
yes, my lord,
the
South
earlier
Africa, Scotland, Philippines,
and-
Hong Kong.
Correct. And there are other sports legislation which are intended to agreement with them,
Yes,
and they will be able to prove them.
correct. So I am not duplicating. I have given, my lord, at least 14 instances where they have not followed the model law. My lord, now kindly come to page 39. Now I am jumping, my lord, from 18 to 39. My lord, my respectful argument is para 49. Lord, as my lord, it fell from the honorable court, can modification be not a subset of setting aside? Lord, therefore, my lord, my respectful submission, I would rather, my lord, read this para 49. Secondly, considering the above, the power of modification, if any, cannot be considered to be a subset of the power of setting aside. The judicial plane at which the setting aside power is exercised is at a very high threshold. Look, this I have taken from various judgments, very high threshold. And therefore, it cannot be stated that power of setting aside would subsume the power of modification. It is submitted that while admittedly the power of setting aside is a larger power, wherein the entire award is set aside, the power of modification exists at a different judicial plane, requiring different judicial parameters and different judicial or legislative approach to enable the same. The power of modification cannot be ipso facto assumed to be a subset. Lord, now kindly, my lord, directly come to page 52. My lord, I have given judgments, my lord, of Canada, etc. My lord, Canada, Singapore, etc. I am not reading it, but I would earnestly urge your lordship, my lord, to at leisure go through it. My lord, it would be really assisting the court. My lord, I will directly come to page 52. And I will not, my lord, repeat it. My lord, I have quoted, am I with your lordship, my lord? Article 5. In matters governed by this law, no court shall intervene except where so provided in this law. My lord, we have adopted this very model under section 5, that whatever is the power legislature has conferred, that is the power the court can exercise. This is not an original power. This is not an inherent power. This is not an appellate power. Whatever powers are conferred are the powers of the court under this act, my lords. My lord, I have given the judgments, my lord, of all jurisdictions under order, my lord, the Article 5, which is our section 5. My lord, I am not reading them, my lords. Kindly, my lord, now come to page 68. There are two judgments of the Honorable Singapore Court. Lord, I am my lord, tempted to read them because one of them is followed by our court. My lord, rest, I request your lordships, my lord, to go through for, my lord, not wasting your lordship's time, my lord, I am jumping over them. My lord, these are under 34(4). My lord, I think, my lord, that's not the subject matter of reference. What are the contours of remittance? And therefore, my lord, I may not dwell, my lord, but if your lordship so considers that it is necessary to assist, my lord, I have the judgments on this point.
Okay.
My lord, would your lordships like me to assist on 34(4)? Because it's better, my lord, not to
You
enhance.
can't go by what others have interpreted. They have done it, but that's a fact. You are saying that most of the other countries have not incorporated term set off. Modify in the term set off, and therefore, clearly, when the parliament enacted the law, they were clear that only
Yes, my lord.
fully or partially set off awards can be dealt with. And as far as section 36 is concerned, 36 is concerned, that's as far as modification is concerned, that's not permissible.
Lord, please come to page 76 now. Lord, one judgment, only one line. It's a detailed discussion, my lord, again Singapore High Court, CAI versus CAJ, the reasonably recent 2021 judgment. But please see para 239, where they take note of what I am respectfully urging. There is no mention of the court's power to vary or amend an arbitral award in the model law or any other section of IAA. IAA means, my lord, Singapore law, international law. We follow model law, so is Singaporean international law. As such, it is clear that under the IAA, the court does not have the power to vary or amend an arbitral award in a setting aside application. But please note, we follow Article 34 of UNCITRAL. Singapore follows Article 34 of UNCITRAL in case of international arbitration, which is IAA, and this is the judgment. The court's power are limited to either setting aside the award or, where appropriate, to suspend the setting aside proceedings and remit the award for tribunal's decision under Article 34(4) of the model law. Then, my lord, 244. While the court has no powers to vary an arbitration award, I agree with CAI that it is empowered. CAI, my lord, is a petitioner, empowered to make ancillary or consequential orders to give effect to its setting aside orders. Now, your lordships may, my lord, kindly directly come to my lord, page 88. On 34(4), what are the contours, what are the parameters when the court would exercise the power of remittance, my lord, are discussed by our court, my lord. There are three judgments, my lord. This Kinnari Malik is the lead judgment, my lord. I may read that, my lord, and leave the rest, my lord. My lord, I may rather, my lord, read the last, my lord. Please come to page 90, I pay, where, my lord, I think my lord, this is Vishwanathan appeared, my lord.
For a change succeeded.
My lords always succeeded.
Yes, please.
But please come to I pay, my lord, it starts at page 90, page 91, para 33. In Kinnari Malik, my lord, which was cited by me earlier, my lord, which I did not read, versus so-and-so, relied on by the learned senior counsel for the appellant, the question which fell... I am reading para 33 at page 91. In Kinnari Malik versus so-and-so, relied on by the learned senior counsel for the appellant, the question which fell for consideration was whether Section 34(4) of the Act empowers the court to relegate the parties before the arbitral tribunal after setting aside the arbitral award, in absence of any application by the parties. In fact, in the said judgment, it is held that the quintessence for exercising power under 34(4) of the Act is to enable the tribunal to take such measures which can eliminate the grounds for setting aside the arbitral award by curing the defects in the award. In the judgment in Dyna Technologies, it was a case where there was no inquiry under Section 34(4) of the Act, and in the said case, this court has held that the legislative intention behind Section 34(4) is to make the award enforceable after giving an opportunity to the tribunal to undo the curable defects. Somewhat similar, my lord, what Mr. Datar was saying. It was not a case of patent illegality in the award, but deficiency in the award due to lack of reasoning for a finding which was already recorded in the award. This is Dyna, not this judgment. It is paraphrasing Dyna. In the very same case, it is also clearly held that when there is a complete perversity in the reasoning, then the same is a ground to challenge the award under Section 34(1) of the Act. Now, please come to 37. In our view, Section 34(4) of the Act can be resorted to record reasons on the finding already given in the award or to fill up the gaps in the reasoning of the award. There is a difference between finding and reasons, as pointed out by the learned senior counsel appearing for the respondent in the judgment in so-and-so versus so-and-so. It is clear from the aforesaid judgment that finding is a decision on an issue. Further, in the judgment of Ashoka so-and-so, this court has held that reasons are the links between the material on which certain conclusions are based and the actual conclusions. Further, Section 34(4) of the Act itself makes it clear that it is a discretion vested with the court for remitting the matter to arbitral tribunal to give an opportunity to resume the proceedings or not. The word where it is appropriate itself indicate that it is the discretion to be exercised by the court to remit the matter when requested by a party. When application is filed under Section 34(4) of the Act, the same is to be considered keeping in mind the grounds raised in application under 34(1) of the Act by the party who has questioned the award of the tribunal and the ground raised in the application filed under 34(4) and the reply thereto. Merely because an application is filed under 34(4) of the Act by a party, it is not always obligatory on part of the court to remit the matter to arbitral tribunal. The discretionary power conferred under Section 34(4) is to be exercised where there is an inadequate reasoning or to fill up the gaps in the reasoning in support of the findings which are already recorded in the award. Under the guise of additional reasons and filing up the gaps in the reasoning, no award can be remitted to the arbitrator where there are no findings on the contentious issues in the award. If there are no findings on the contentious issues in the award, or if any findings are recorded ignoring the material evidence on record, the same are acceptable grounds for setting aside the award itself. Under the guise of either additional reasons or filling up the gaps in the reasoning, the power conferred on the court cannot be relegated to the arbitrator. In absence of any finding on contentious issue, no amount of reasons can cure the defect in the award. A harmonious reading of Section 31, 34(1), 34(2)(a), and 34(4) makes it clear that in appropriate cases on the request made by a party, court can give an opportunity to the arbitrator to resume the arbitral proceedings for giving reasons or to fill up the gaps in the reasoning in support of a finding, which is already rendered in the award. But at the same time, when it prima facie appears that there is a patent illegality in the award itself by not recording a finding on a contentious issue, in such cases, court may not accede to the request of a party for giving an opportunity to the arbitral tribunal to resume the arbitral proceedings. But pausing here for a minute, Lord, the jurisprudence in Singapore has a very interesting jurisprudence. What it says, similar provision, my lord, in the international part of Singapore law, that if a court comes to the conclusion that it deserves to be set aside, 34(4) is a mere option available. You cannot say that it deserves to be set aside, but I'll still remand it. The defects should be of such a nature which you will find appropriate that it is possible to cure, and therefore the word, if the court finds it appropriate, are relevant.
Therefore, discretion.
Therefore, discretion. It's not a second round, and the second set of expenses by the parties. So 34(4) will have to be very sparingly used. Otherwise, it would be very expensive. Arbitration is an expensive remedy. Mhm. More minutes. Lord, I'm just inviting your lordship's attention without reading it. Please come to 95. Lord, 95 are the list of judgments I'm not reading. Pre-Hakim's regime, where your lordships modified. They fall in two categories. Either there is no discussion and direct modification, or your lordships have said 142. That's it. Lord, then your lordships may directly come to page 1110. In India also, wherever the legislature in the realm of arbitration intended to provide for modification, even our legislature has also, my lord, provided. I have given the illustration, my lord. My lord, in Bihar, there is Bihar Public Work Contract Dispute Arbitration Tribunal Act. In Bihar, there is Madhya Pradesh, Chhattisgarh, and Gujarat. There is a power, specific power of modification. Lord, then page 114. Lord, I'm just paraphrasing, I'm not reading it. Lord, one of the possible argument I anticipate is that till the legislature legislates or clarifies on the question of modification, please lay down the guidelines as your lordships have done in Vishaka. Lord, that is with little a worrisome situation for two reasons. A, Lord, we are not dealing with a Vishaka situation where there is complete vacuum.
There was no legislation there.
There is no legislation there. There is a legislation. Number two, and most important, your lordships have resorted to Vishakha, my lord, power when fundamental rights are violated. Arbitration are all contractual and statutory rights. Any laying down of the guideline would be nothing but judicial lawmaking, Lord, which Vishakha also does not permit.
No,
Good
Vishakha
luck.
said that till an approved legislation is made.
Because a positive obligation is formed
Yes,
and there is a vacuum.
It was to
That-
operate only till the legislation was made.
correct. Here in Vishakha, there was no legislation dealing with this.
There are two things. If we hold that setting aside does not include modification, that's the end of the matter. If we hold to the contrary, that's the second thing. That setting aside will include modification,
Then guidelines may not be necessary.
but modification only in this set of circumstances. We are not legislating.
Correct. Your lordships
Not
are
legislating. That's within the permitted
lordships
corners
are
of law.
defining the contours of exercise of power.
We didn't legislate when we said death penalty is going to be given in raiders of Vegas.
Correct. I am
But
not
we said
pitching
we
that
are
high.
not legislating, please.
Your lordships are only in that scenario defining the contours of the powers which your lordships have found
Correct.
power to modify, that it should be done within this area.
There is only one way we have to hold that we have one setting aside has the power to modify or power to vary, but limited to that, then we can lay down the parameters when that power can be exercised.
Correct. Provided your lordship can trace modification power somewhere. Yes.
The greater
Now
it is,
last-
smaller, if that principle is followed, then we can.
Well, last point, page 128. Lord, how your lordships can possibly read a merit review also and power of modification.
130,
128. The field is occupied by two judgments and one is, my lord, Constitution bench. My lord, one is SBP and Company versus Patel Engineering. Please come to, my lord, page 129, the highlighted part. My lord, suppose somebody were to challenge an arbitral award in a 227 saying that 34 is not an efficacious remedy because it is restricted by the contingencies under subsection 2. Lord, this is the answer given by the Constitution bench. It will still be a forum chosen by the parties by agreement. That is, my lord, arbitration. We therefore disapprove of the stand adopted by some of the high courts that any order passed by the arbitral tribunal is capable of being corrected by the High Court under Article 226 or 227 of the Constitution. Such an intervention by the High Court is not permissible. The object of minimizing judicial intervention while the matter is in the process of being arbitrated upon will certainly be defeated if the High Court could be approached under 227 or 226 of the Constitution against every order made by the tribunal. Therefore, it is necessary to indicate that once the arbitration has commenced in the arbitral tribunal, parties have to wait until the award is pronounced unless, of course, a right of appeal is available to them under section 137.
Contra argument over here is that the power under Article 227 is a
Constitutional power cannot be taken away. That is held by a two-judge bench, my lord, in Deep Industries, which, my lord, I have 137, my lord. Your lordships may kindly come to 137 and I end it. I'm sorry, my lord. Next.
Will it not go contrary to Chandra Kumari?
But the first judgment,
No, this 5 judges view.
that's for first SBP. No, Chandra Kumar also says that High Court and Supreme Court, High Court cannot, only CAT can.
No,
That was held in Sampath Kumar. So Sampath Kumar got reversed in Chandra Kumar.
L. Chandra Kumar, your lordship,
Yes.
L. Chandra Kumar.
L. Chandra Kumar.
L. Chandra Kumar said that because the CAT is constituted under the Constitution, it would oust 226 and 2.
No. That was what was held in Sampath Kumar. But in L. Chandra Kumari, the court says that the powers under Article 226 and are part of the basic structure of the Constitution, and then by way of caution, they said that it will whatever is decided by CAT and MAT it will go before the revision bench of the High Court.
Yeah, yes, but directly what is capable of taking before CAT cannot be brought to the 226 court. That's what they have said. Otherwise, your lordships are right.
Probably
Now,
you
my
want
lord,
to
this
say
is deviation from.
existence of the power to interfere is one thing, exercise would be.
Correct.
It will all come into the latter category.
Normally, but here it says it is impermissible. Constitution bench uses, my lord, final word that it is impermissible. But please see the two-judge bench thereafter in deep industries versus ONGC. My lord, only para 7 highlighted part.
Page,
The same page, my lord, page 129.
deep industry.
Deep Industries versus ONGC. This is a two-judge bench, refers to, my lord, SBP. It's not, my lord, per incurium, and says this, para 17. This being the case, there is no doubt whatsoever that if petitions were to be filed under 226, 227 of the Constitution against orders passed in appeals under Section 37, the entire arbitral process would be derailed and would not come to fruition for many years. At the same time, we cannot forget that Article 227 is a constitutional provision which remains untouched by the non-obstante clause of Section 5 of the Act. In these circumstances, what is important to note is that though petitions can be filed under Article 227 against judgments allowing or dismissing first appeals under Section 37 of the Act, yet the High Court would be extremely circumspect in interfering with the same, taking into account the statutory policy as enumerated by us herein above, etc. As my lords have said, existence of power is one thing, its exercise and discretion is another thing. My lord, there are other judgments also on the point, my lord. I am not reading them. My lord,
But if a party only wants a modification, and if you say it is not covered by the statute, will it not be a matter exclusively within the jurisdiction of the High Court?
maybe.
Because the Act doesn't contemplate that at all.
Maybe, well, maybe. I would not say yes or no, but it is not possible to say right now that the High Court would have no jurisdiction. High Court would retain the jurisdiction. Lord, I have also given the list of countries which have adopted Article 34, my lord, in my documents which are filed. I'm not going through them. But I'm really grateful, my lord. It's subject to if my learned friends want to add anything. But if needed, my lord, kindly give me some time for rejoinder. The reason is, it's not matter where we should lose or succeed. That's not the issue. But on this point, your lordship's judgment would be the first judgment, to my knowledge, my lord, in any of the jurisdictions of the world. So, my lord, we may not be lacking in assisting your lordships on any point. That's the only reason.
You're supporting what?
Let's be supporting Mr. Mehta's arguments
No,
I
you're
think-
supporting for modification or against
Yeah.
what? You're,
against model.
Against
no,
modification.
no, we'll first hear the one who wants modification.
Just for housekeeping purposes.
No, please, we'll first hear who wants modification.
Of course.
You are the status quo.
We only uphold the law, as my boss will declare.
Yes, please.
Yes, Lord, I filed a 3-page submission and broadly,
Mr. Banerjee,
So I'll-
for
I will-
UNCITRAL.
So my lord, we will rejoin, my lord.
We will-
We'll rejoin.
I filed a
Because
3-page.
till they make out a case, and some of them may be saying complete, some of them may be saying less, and therefore it will be better for you if you can.
Certainly, certainly.
Just in that the UNCITRAL can also complete against modification, and I leave it to your lordship. I can.
You start.
All right. Number Lord, broadly speaking, without going to this, my submissions are this, Lord, that the Section 34 has been hastily put into our act. It is not intended for domestic arbitration. In fact, the insertion of subsection 2A by the 2015 amendment itself shows that they requires a separate treatment for domestic arbitration. First point. I'll go to UNCITRAL model and say why 34 is a misfit. Second submission, Lord, is that the power to set aside will include the power to partially set aside. St. Xavier's 9 judges say that the larger power always includes the lesser power. Mohammed Kunni says that if I can do something at the end, I can also do it earlier. So power to set aside includes power to partially set aside.
So that is, section 34 itself provides for.
So 34 doesn't provide for partial set aside. Yes, only the proviso.
The provides
Proviso, yes.
clause 4
And-
of,
Yes, but 34 is in two parts, 34-2A and 34-2B. There are two parts. And lastly, my submission is, I have made a small note, a chart. My suggestion is that if we can add two words, three words in 34-2B and just two words in 34-2A, a lot of the problem can be sorted out in my submission. And I've given at least 8 judgments where Supreme Court has added a word so as to make, so that absurdity doesn't result. And there's a wonderful judgment of the Bombay High Court where a phrase has been added to prevent absurdity in the statute or make the statute unworkable or ineffective. Now, my lord, kindly see the objects and reasons of the act. My lord, I've made that additions also. I'll place it before the court. Now, kindly see the objects and reasons of the act. Lordship will note, my lord, this act was intention was to codify and consolidate all the laws regarding arbitration. Earlier, as Justice Vishwanathan pointed out, it was scattered. You had the Foreign Awards Act, the Enforcement Act, and the Domestic Act. So the very opening paragraph of the statement of objects and reasons says that everything has to be consolidated. Lordship has got statement of objects and reasons. The opening part on top says,
There only as the preamble.
Lord, I've got in this book on Universal, there is a introduction.
Yes, it is. Introduction is there. Below that statement.
Yeah, below that statement of objects and reasons. The law of arbitration in India is at present substantially contained in 3 enactments, namely the Arbitration Act 1940.
Brother, wait. Brothers are reaching.
Sorry, my apologies. But I've got the Universal Book of 2024.
we have the same book.
Same. So, Lordship will just take page 1. All your Lordships have got it. Very.
After the introduction.
Yes. But introduction is the work of the editor. I'll go by the statutory provision, which is the statement of objects and reasons. The law of arbitration in India is at present substantially contained in 3 enactments, namely the Arbitration Act 1940, the Arbitration Protocol and Convention Act 1937, and the Foreign Awards Recognition and Enforcement Act 1961. It is widely felt that the 1940 Act, which contains the general law of arbitration, has become outdated. The Law Commission of India, several representative bodies of trade industry, and experts in the field of arbitration have proposed amendments to this Act to make it more responsive to contemporary requirements. It is also recognized that for our economic reforms to have not become fully effective, if the law dealing with the settlement of both domestic and international commercial disputes remains out of tune with such reforms, like arbitration, conciliation is also increasing worldwide, is getting increasing worldwide recognition as an instrument for settlement of disputes. There is no general law on the subject in India. Then, my lord, para 2 is the UNCITRAL Model Law. I'll read that. The United Nations Commission on International Trade Law, UNCITRAL, adopted in 1985 the Model Law on International Commercial Arbitration. The General Assembly of the United Nations has recommended that all countries give due recognition to the said model law in view of the desirability of uniformity of the law of arbitral procedures and the specific needs of international commercial arbitration practice. UNCITRAL also adopted in 1980 a set of conciliation rules. The General Assembly of the United Nations has recommended the use of these rules in cases where disputes arise in the context of international commercial arbitrations and the parties seek amicable settlement of the dispute by resort to conciliation. An important feature of the model law and rules is that they have harmonized concepts on arbitration and conciliation of different legal systems of the world and thus contain provisions which are designed for universal application. Now, para 3 is extremely important. Though the said UNCITRAL model law and rules are intended to deal with international commercial and conciliation, they could, with appropriate modification, serve as a model for legislation on domestic arbitration and conciliation. Lordship will kindly emphasize on appropriate modification. No modification has been done as far as the Act is concerned. Now, Lordship will kindly have summarized the model law and just 2 small changes have been made. So, And in fact, the Lok Sabha debates, there is saying that it's done hastily, you're not taken into account all those points. Lok Sabha debates are there. But the fact remains that the objects and reasons said that this is a law meant for international arbitration, where the participants are from two different countries. That we'll adopt with modification. Now, Lordship will just come to page 93.
Tushar, we will not be able to go into the question because if I'm not mistaken, when the act was made, 85 itself led to a lot of debate. Section 85, because there were a number of ordinances and then modifications and then finally passed. Finally, the act.
No, but what happened was the arbitration ordinance came in 1996. In fact, on a personal note, the very first case in India on arbitration ordinance was the Madras High Court, where I appeared, and we had this new provision of section 34. That was the first case in India on this.
So 85 itself went in for which
No,
one will apply?
1940, after 19...
Three rounds of ordinance repeated, and there were a lot of consultations.
There was a lot of controversy. So don't go on that.
No, I'm on the basis that section
Yeah,
34.
go on the core principle that the word setting aside the greater power includes the lesser power is a well-known concept. And why do it if it is cut short litigation? After all, the object of legislature can or not mean to say that obvious things cannot be corrected.
Correct.
And obvious mistakes cannot be corrected.
Yes.
And that will not amount to modification of.
I'll get your Lordship's point. What I'm...
Doctor, you may not be right.
Yes.
All international commercial arbitrations are not foreign-seated arbitration.
Pardon me?
All
Correct.
There are India-seated international commercial arbitration.
Yes.
For which part one will apply.
Yes.
So it is wrong to say that, there
No,
was
but
no uniformity.
No, the definition of international commercial arbitration is one party is
Abroad.
foreign.
And
So-
if it is seated here, part one,
Yes.
seated abroad, New York Convention.
Yes.
So part two.
Yes.
So when they say, though they said UNCITRAL model law and rules are intended to deal with international commercial arbitration and conciliation, they could, with appropriate modifications, serve as a model legislation on domestic arbitration.
Yes.
So
The
it includes one category of international commercial, which part one applies.
Yes, true. But the point I'm raising is this difficulty which we have faced for the last 20 years and this kind of continuous confusion on arbitration resort to Article 142 and so on is because Article 34 of the UNCITRAL Model Law is necessarily a pure international arbitration where there are two parties in two different countries. That's the context I wanted to give to Lordship. My Lordship said no need to go into it, but Lordship will just take it from me that 34, which was there in the UNCITRAL Model Law, is meant for two nation arbitrations. And that's what the explanatory note says in the United Nations itself. Now, what they proposed was they'll take section 34. See, what happened was they're going to make the 96 Model Law as the basis. If your Lordship sees chapter 3, chapter 4, etc., identical copy, starting of arbitration, terminal proceedings, identical copy of UNCITRAL Model Law. We come finally to chapter 6, which is recourse against an arbitral award. Then there they put in 34. Now, what they put in 34 is something which can never be contemplated for domestic arbitration. That's why, as the learned solicitor said, many countries who are signatories to UNCITRAL Model Law, they took the trouble of drafting separate domestic arbitration laws. UK, Australia, Canada, Singapore, they are all signatories. But they chose to take a different step. Now the point is we can't judicially legislate. This court can't put a new section like UK. But we can make repairs, small repairs, and as Lord Denning put it, is going to be my final submission. If there is a complete inconsistency and the section is crying, begging for change, we can't wait till the legislature changes it. Your Lordships, in my humble submission, can add just a few words which I have drafted and put it for your Lordship's kind consideration. If you agree with that, in my submission and subject to what my colleagues here say, we can have a particular solution to the problem. Now, today, what is the problem, Lord? An arbitral award is horribly wrong. Mr. Khambata's case is egregiously bad. He will come to it when his turn comes. It's a dissenting award, 2:1. The majority award is completely contrary to basic principles of law. Completely contrary. The dissenting arbitration is absolutely correct. What is the remedy? Set aside the award. Take another example my Lord the Chief Justice gave. There are 5 issues. A, B, C, D, E. D is patently wrong. But D is not severable. And that D is wrong, not because of the powers of the parties. The tribunal did not made per incurium, or they completely went egregiously wrong, patent illegality. Though I have succeeded on A, B, C, and E, because of the D, which is like the drop of poison which destroys the whole mill, whole award has to be set aside. Now, the arbitral section 34 doesn't say after set aside, do what? Where is the power to say it will be remanded back?
No, in that case, 43 will come into picture.
42.3 says we'll exclude tribunal. That's
If
only
what
taken
for,
account for us.
if the arbitration clause doesn't evaporate, then you can invoke
You
fresh
can invoke,
arbitration.
yes. Now my point is, now the question arises, suppose on the second round, one more illegality is there, what happens?
No, that can be.
I mean, where do you keep
No,
on
no,
going?
that should not be, that should not be an argument.
No, my Lordship is right.
That should
So,
not be an argument.
I was just saying, my lord, just see section 34 of the explanatory statement. Why 34 was introduced? Because they said different countries have different laws to set aside an award. We want to bring in uniformity. If your lordship will just indulge me.
That's correct. You were right on that way,
Yes.
because if you look at the provisions, the way they were,
At
it
that
was, yes, probably,
Chaos, yeah.
it was probably like an international cooperation to have at least a uniform arbitration, international arbitration, something like the New York Convention,
Yes.
which basically primarily based
Yes,
on,
yes.
if you look at the clauses also, they're primarily based.
But then the basic thing is clarity and consistency. The 2 points of international law is clarity, consistency. So everybody knows where they stand. Now, lordship will kindly see, just come to page 93. Just 2 sections I'll read and I'll proceed further. This is important. 93 of the compilation. I've also given soft copy, sorry. Ironically, in 2006, they provide for amending interim award. What about? Please come to page 93. Article 1(1). This law applies to international commercial arbitration subject to any agreement in force between this state and any other state or states. Now, please come to the definition of court at page 94, Article 2C. Court means a body or organ of the judicial system of a state. Now, straight away come to Article 34. And I reproduce all these articles to show that everything has been lifted and put into our article, our Arbitration Act, section 16, section 17, 30, 31, 32, 33. And finally, please come to chapter 7, which is at page 900. Now, 34.2. Lordship has got 34.2. An arbitral award may be set aside by the court specified in Article 6 only. So that has been deleted. May be set aside by the court that specified in Article 6 is cut off in our Act. Only if. Then it goes on. Then B, identical 1, 2, 3, 4, including the proviso, B also. And the last one, B2, the award is in conflict with public policy of this state. It has become of India. Apart from that, there is no change. Now you please come to Article 36. Now, Chapter 7, we make it different. We provide arbitration is final. It will be like a CPC. When you go to Chapter 7, we have redrafted the section. Article 36, grounds for refusing recognition or enforcement. And Lordship will kindly see, it is identical to 34. Now come to page 108 as to why this was necessary. Page 108. Para 44, may I read 108. The disparity, Lordships have got para. The disparity found in national laws as regard the types of recourse against an arbitral award available to the parties presents a major difficulty in harmonizing international arbitration legislation. Some outdated laws on arbitration, by establishing parallel regimes for recourse against arbitral awards or against court decision, provide various types of recourse, various and often long time periods for exercising recourse, and extensive lists of ground on which recourse may be based. Part 2 explanatory note. That situation of considerable concern to those involved in international commercial arbitration is greatly improved by the model law, which provides uniform grounds upon which and clear time periods within which recourse against an arbitral award may be made. Then, my lord, they mention what are the applications. Kindly come to para 46. As a further measure of improvement, the model law lists exhaustively the grounds on which an award may be set aside. This list essentially mirrors that contained in Article 36(1), which is on enforcement, which is taken from Article 5 of the New York Convention. The grounds provided in 34(2) are set out in two categories. Grounds which are to be proven by one party are as follows: lack of capacity, etc. That's to all this is 34(1)(a), where the applicant has to say what are the grounds to set aside the award. That is 34(1)(a). Now on page 109, grounds that a court may consider on its own initiative as follows. That is 34(2)(b), non-arbitrary subject matter of or violation of public policy, which is understood to be a serious departures from fundamental notions of procedural justice. The approach under which grounds for setting aside the award under model law parallel the grounds for refusing recognition of the award under Article 5 is reminiscent of the approach taken in the European Convention on International Commercial Arbitration, 1961. Under Article 9 of the latter convention, the decision of a foreign court to set aside an award for reason other than the one listed in Article 4 does not constitute a ground for enforcement. The model law takes its philosophy one step further by limiting the reasons for setting aside. That's the reason given. Now, I have also reproduced at page 111, because this is the 85 as amended with 2006. And here again, the same point is there. Lordship will just come to page 114. This is from Mr. Chandrasekhar Rao's book, where you get a copy of the 85, original 85 law. Now, Lordship will just come to page 115. Existing national laws provide a variety of actions or remedies available to a party for attacking the award, often equating, etc., etc. So my submission is the problem now that was created for India was taking section verbatim and putting it into the part relating to domestic arbitration, and that's what creates the problem. Now, please come to the arbitration section 34 itself. Now, my lord, see the amendments that had to be made. One was adding the explanation. But today, my lord, my submissions are confined to domestic arbitrations. Domestic arbitration. So please come to 2A. An arbitral award arising out of arbitrations other than an international commercial arbitration may also be set aside by the court if the court finds that the award is vitiated by patent illegality appearing on the face of the award, provided that an award shall not be set aside merely on the ground of an erroneous application of the law or by reappreciation of evidence. Now, my submission is 2A is itself a recognition that 34 on a standalone basis will not suffice. For domestic arbitrations, they require some element of judicial risk, and Parliament has provided patent illegality appearing on the face of the award. So illegality must be patent It should not be latent. And the further proviso says you can't set aside merely on the ground of an erroneous application of law or by reappreciation of evidence. Now, under section 34 as it stands, can we read in an inherent power to modify the award? And as all lordships have remarked, the larger power always includes the lesser power. Since Xavier's judgment is there, I can give the para number. Lordship may also note Pepsi Foods where they say the larger power includes the smaller power. Now please see my note, my lord. Page 2. Page 2 of my written submission. I'll quickly run through it so the others can start.
Yes.
Yes. Now, my lord, I have read out, please come 2.5 and then I'll go to the next paragraph. Several other nations, which were also signatories to the UNCITRAL Model Law, made separate provisions for domestic awards to be modified, various set aside. For example, Section 69 and other sections of the English Arbitration Act, 49 of the Arbitration Act, 2001, etc. I think learned solicitor has given the various examples of other countries. Now, this is the next point I'm making. Section 34 refers to powers to set aside the award. It is a basic principle that a larger power includes a lesser power. This is based on the maxim so and so, which means the greater contains the lesser. A bench of 9 judges has also held that the greater power contains lesser power. See Ahmedabad Xavier Company, and also Atmaram also is
If
important.
we accept this argument,
Yes.
there are two difficulties.
Yes.
One is that the legislature, the contention is legislature deliberately did not confer on the courts the power to modify, which was earlier there in 1941. Which was there in 1941. Secondly, where do and how do we draw the line to modify?
Yes. My answer is you draw the line to modify. It is not a first appeal power under section 96 where you can reappreciate everything. That power to modify, the drawing, I mean the line or the Lakshman Resha, so to speak, it has to be patently illegal. Once you take patent illegality, and which has been explained by the court in number of judgments.
Look, there's difficulty.
What?
Patent illegality, we set aside the award.
What?
Obviously, we don't re-adjudicate. We don't re-adjudicate.
No, that's what I'm saying.
Courts do not,
No.
because that's also part, look, if we accept, we have the power to modify, then where does the court power end?
Yes. Where do you draw the line?
Where do
Can
you
you go
draw?
all the way or do you draw a line? Where is this? Where is the question? My answer is the power
And,
to...
and that's the difficulty when the legislature doesn't draw a line.
Yes.
It can be argued that the legislature never intended that power to be there.
Yes. But when I come to the end of after this submission, my submission is the Gayatri Balaswamy's case, which is now before your lordship. It first came before a single judge. And in that judgment, Justice Ramasubramanian, as he then was, he has given in 7 paragraphs why there is always a power to modify the award, even within the limitations of section 34. If your lordship sees that, and it's a constitution bench, it's a bench of 5 judges, your lordships are untrammeled by precedent. There is no judgment of a 5-judge on the issue of arbitral award modification. So lordships are not bound by any precedent. Your lordship can set the law, whichever way your lordship feels justice has to be done. But kindly see the reasoning of Justice Ramasubramanian. That may give some idea as to why we should read the power to modify by itself. And towards the end, I will say, just add 2 words in section 34A, add in 34.2A, add 2 words in 34.2B, and the problem is solved substantially, is my humble submission. First, let us go to Justice Ramasubramanian's judgment. Well, I've got hard copies also. Now, my lord, your lordship will just make a note. Lordship will just note in serial number in the list of cases. Lordship will just note, Puri Construction, Delhi High Court says no modification. Lordship will just make a note so that I don't.
Which the serial number.
In serial number 10, no modification. The Bombay High Court, full bench, gives a well-reasoned order why there is modification, why there should be modification.
Bombay High Court says full bench modification.
Modification. Now, please come to Gayatri Balaswamy's
Lord,
case.
may just note that is on partial set aside and not modification.
Correct. No, I am saying,
Doesn't say
difference.
no, I am saying modification is equal to partial set aside can be modification also. That's my point. Why do you say the larger includes the lesser? I need not set aside 100%. I can set aside 18%, 20%,
So
whatever.
probably the other side is accepting there can be partial setting aside.
No, they don't.
If it is permissible, in view of how the award has been drafted, if the severability is possible, they accept it.
Suppose it is not severable, then what happens?
Then, no, if there are issues there. Severability, probably both the sides are now at item that there would be no difficulty. Because you are supporting it, they are not
No,
opposed.
in fact, 34(2)(a) also says so.
34(2)(a),
no,
no,
also says
2(a)(4) partially.
Exactly.
Partially. It cannot be said completely. It cannot be said like, let's take the example where there are counterclaims and claims.
Or like we challenge.
Not because counterclaims and claims can be at times completely separate, but at times connected also.
Yes. Yes, you're also right.
And in fact, we have a case in which counterclaims have been rejected, claims have been, now, both were allowed, partially allowed.
Yes.
And balancing out equity or what is pronounced. The High Court says the counterclaim should not have been allowed because the long principle of law is applied by the arbitrator and patent illegality set aside. The irony is now in the law, the claims will stand on a different footing, counterclaims will stand on a different, like they could have been two separate arbitrations also.
But a common arbitration award is passed.
There is a common arbitration. Now, under the award, amount will be payable under the claims.
Lord, my submission is, unless your lordship reads the power of modification in the sense not to.
You're going back to section 15, limiting.
No, not necessary. I'm not saying going to that extent at all. I'm going to give the contours.
15 is restricted part, except in under clause.
Yes, yes.
15 is a very restricted
No,
part.
I see 15 did not have the concept of patent illegality. 15 did not say don't appreciate evidence. 15 gave a complete open power to the courts to modify the award. I'm saying that ship has sailed. Nobody now says in arbitration regime you give that power. But look at where we are come now. Because of
3033 was far wider.
33, exactly. And as just look, when we
3033
were juniors,
was much wider.
but when we were juniors, the person who files an application to make it into a decree, we will file an objection saying why the award is to be set aside under 3033. So there will be two OPs in Madras at least. And both the OPs will be taken up for hearing and there will be a common judgment.
Everywhere.
Yes. Same, you don't have the power to modify.
Let's see the Madras High Court judgment.
Madras judgment, yes. Because we have now a situation where the government has issued a press note about 10 crore, no arbitration. I mean, can you imagine the third largest economy not having an arbitration provision? Very serious matter, my lord. We can't simply say set aside, no set aside. A person who has got an egregiously bad award, you can't simply say, sorry, we throw our hands up, you go back. Page 160. Please come to page 166. Yes. And my lord, the judgment starts at page 176. Now please come to page para 52. The learned judge put forth the question as to whether we have the power to arbitrate. Lordship will just come, Lord. It's a very, very well reasoned. Yes. Yes, Lordship will kindly come to page 181 where the issues are framed by the learned single judge as he then was. 181 bottom.
Yeah.
Para 23. Lordships, please come to page 181, para 23 at the bottom. I read, my lord. Therefore, just see above para 23 in italics. Therefore, the prayer in the present petition cannot strictly be construed as one for setting aside the arbitration award. It is actually for modification of the award in such manner as to allow those claims which were disallowed by the arbitrator. Therefore, two questions arise for consideration. They are: one, whether in a petition under section 34, this court is entitled to modify the award either by enhancing the amount awarded by the tribunal or by granting a relief that was rejected by the tribunal, especially in the light of the express language of section 34, and B, if the answer to the first question is in the affirmative, whether the petitioner is entitled to grant so and so. Now, my lord, kindly come to section 24. Then you please come to para 29, where he refers to section 15 of the Arbitration Act. And then for para 30, he discusses various cases. Lordship will kindly see para 29. Under section 15 of the Arbitration Act 1940, the court was conferred with the power to modify or correct the award.
There are two things. Where courts have done it, but without examining the power of the court.
Correct.
That will not help you. Where the courts have examined the contours of section
Yes.
34, those decisions will be helpful.
Correct. The lordship will discuss all that.
When we rely upon judgments of the
It is seen that the judicial trend appears to favor an interpretation that would. It is seen that the judicial trend appears to favor an interpretation that would read into section 34 a power to modify or reverse or vary the award. Read into section 34 a power to modify or reverse or vary the award, except one observation found in the decision of the Supreme Court in McDermott. All decisions of the Supreme Court have either modified the award or approved the modification of the awards done by the courts under section 34. At this stage, it may be useful to have a look at similar provisions, so and so. Then his lordship takes the trouble of going through various foreign provisions up to Singapore. That goes on. Yes. Now please come to page 191. 191.
Yes.
Now please come to para 50. Keeping the above global scenario in mind, if we have to look at the language of section 34 of the Act, it appears that the same also favors such an interpretation. Now, Lordship will kindly see just above that, his Lordship refers to Singapore, right? As if reiterate such a conclusion, section 51, which is made applicable to both 48 and 49, speaks of varying an award under subsection 2 of 51. Therefore, sections 47 and 51 to the Singapore Act make it amply clear that the power to set aside includes the power to vary the award. Keeping the above global scenario in mind, if we have to look at the language of section 34(1) of the Act, it appears that the same also favors such an interpretation. I have already extracted 34(1). This is important. What 34(1) says is that recourse to a court against an arbitral award may be made only by an application for setting aside in accordance subsection 2 and 3. Therefore, section 34(1) is obviously divided into two parts. The first part conferring a right and the latter indicating a remedy. If we perceive the first part of 34(1) as the sole and substance in which a remedy is to be sought, can never curtail or limit the right which is made available under a statute award. It cannot be construed that the power of the court is limited by 34(1) only to set aside the parties and to leave the parties in a position much worse than what they contemplated or deserved before the commencement of the arbitral proceedings. A statute cannot be interpreted in such a manner as to make the remedy worse than the disease. A narrow interpretation of section 34(1) would actually spell doom for the arbitration regime and create a mischief. Therefore, in my considered view, recourse to a court against an arbitral award appearing in section 34(1) cannot be construed to mean only a right to seek setting aside the award. Recourse against an arbitral award could either be for setting aside or for modifying or for enhancing or varying or reversing an award. The application for setting such an award appearing in 34(2) and 3 merely prescribes the form in which the person can recourse against an arbitral award. The form in which the application has to be made cannot curtail the substantial right conferred by the statute. In other words, the right to have recourse to a court is a substantial right and not liable to be curtailed by the form in which the right has to be enforced, exercised. In my considered opinion.
How do you say that, Mr. Datta? Is it not too broad? Directly contrary to 2 and 3.
Yes. Now, my lord, I also realized.
Don't go by the extreme proposition. It will be very difficult.
Yes, I'm not going. I'm saying.
And therefore, it may not be. If we have to look.
True, I'm not going to that extent. I'm saying this judgment is.
I'm actually saying the court steps into the shoes of the arbitrator. That's not possible.
No, and one more thing is this judgment is,
Court is not an arbitral tribunal.
one more thing, the judgment is 2nd December 2014. The 2015 amendment introduced 34(2)(a) as to show to what extent interference can be there for domestic awards. So but what the learned judge says is recourse to a court means recourse to a court mentioned in 2E of the Act.
That virtually says that then Order 41 principles will be applicable.
No, I'm not going to that extent. Now, my only submission is this, my lord, and I'll go to my submissions. I am only submitting that the power to set aside will always include a power to modify or vary to the extent it is necessary to make the award enforceable. Now, it can't be a binary. It can't be either you set it aside or don't set it aside. Now, if you say you can partially set it aside, what are we talking about? What do you mean by partially setting aside an award? Are we saying that there are 7 issues? And I'm setting aside the award insofar as issue 4 and 5 are concerned and upholding the rest. That's also partially setting aside. Or it could also be a situation. Kindly see, my lord, we are here to make an arbitration because the person must say, instead of going to a civil court, I'll go to arbitration. It is cheaper, faster. And
Not cheaper.
it is cheaper, my lord. It is cheaper. No, your lordship will forget about Delhi arbitration. Arbitration is not so expensive and many arbitrations are not by retired judges also. Many arbitrations are by, like for Bombay Stock Exchange, how many arbitrations take place which never come to court?
Bombay arbitration, that's a.
No, the stock exchange arbitration, the small arbitration.
Rule, regulation based.
Yes,
Statutory
I'm
and
saying there are a number of
regulation-based-
cases.
Right, statutory and regulatory based arbitrations are different.
No, and I don't know about, at least in Madras Arbitration Center, so many small arbitrations are there. In fact,
That's good.
there was a proposal done by Justice A.P. Shah,
That's good.
where every senior counsel had to do 4 or 5 arbitrations pro bono, where the amount was less than 1 crore, 50 lakhs. All of us have done arbitration pro bono in our chambers. So that many cases are there. Not chambers 4 lakhs, 6 lakhs. It's not that these are all multi-crore arbitration. There are a large number of arbitrations which are quite small. I am only submitting, my lord. Let us test when you say partially modify. What are you partially set aside? What are you doing? I'm asking myself the question. Now, suppose I know. Let's say in one particular issue.
What you are doing is setting aside that part, but not modifying it.
I'm saying, I'm putting, why not modify it? I'll put a lordship. On issue number 4, the arbitral tribunal has passed a judgment which is directly in the teeth of a Supreme Court decision. Now, why can't the court under 34 say the Supreme Court has said A plus B is equal to C? The arbitration tribunal has erred by saying A plus B is equal to D. I need not set it aside. I can simply substitute C for D and continue with the award. Why not? Lordship mentioned about the cement part of it. Suppose he has wrongly taken 80 rupees per bag where the amount is 40. Why set it aside? Substitute it. I am only saying trust the judiciary, my lord. We all felt that if basic structure comes, everything can be challenged. It's only 4 times we have done it. Article 226, you got a wide power, but it is also with restraint. So I am submitting, why can't we say that if a particular issue in an arbitral award has gone completely wrong, it's out of track, why can't the High Court or the District Court under 34 put it right? And if the court goes wrong under 34,
May I request the person who was supporting the view modification or if you can assist us and help us.
yes,
When will interference by a court will not be treated as modification? Modification, when will you not treat it as modification? When interfering with the interest not amount to will not be treated as modification. Clerical or arithmetical areas should not be treated as modification. Or there is something which is where
small repairs. What the court says, they are small repairs, minor corrections. Will that be permissible? Lordship is right. We have to actually define what is modification. I'll only mention, Lordship asked the question, what is
because
modification?
There's a reason why modification may not have been incorporated.
Yes.
Because if modification is incorporated without defining what is modification, as it was done in section 50, it will virtually mean that the court then sits into judgment and examines, after having set aside, it examines that. Now, the very fact that the court should not do that while examining 34, because 34 is a summary proceeding. In a way,
In a sense, yes. It doesn't, it's not a section 96 CPC. That's very clear. Neither a section 100 CPC.
It's not like the original.
Yes. Lord, can I suggest what I've suggested in the two, what words can be added? Lordship will see if that makes sense. Because, Lord, I'll study it because what I was grappling with is, what do you mean by modification? Because it's, and as a Lordship knows,
Can we apply the
Yes.
principle that the basic structure cannot be changed,
yes.
but you can?
You can
Yeah.
give me those words, I'll pass it on to Parliament.
Which one?
Addition can take place there.
No, it has arisen in other jurisdictions.
Yes.
Here it's a rent control, very mundane, for a big
Yes.
arbitration case, material alteration. Repairs would not be material alteration.
Correct, correct.
So,
Small repair, small little, just like, small little repairs here and there, which really do not destroy the substance of the award, the substratum of the award, as long as it can fall
My
with.
lord, it would be with unguided, my lord,
That way.
word.
No, we understand that.
What
Just-
small
it's
and
just a
at
question.
what extent that smallness stops. That's all.
But Lordship will just take this. I have underlined it. Take this copy. I have said, Lord, I'm just trying to sort out a problem and I'll work on modification also. Because my point is, when you say partially set aside, what do you mean? When you say modify, what do you mean? Lordship will just, I've underlined the modification which the court has done. I'm saying that the power of the court to add words is not known. Please take this. Pardon me.
This is Tushar Mehta. Normally it's the government side which comes and says, please reduce the interest. Government side which normally comes and says, please reduce the interest. Most of the cases.
My lord,
From my experience, and I think
Lord,
all of us on this side will.
not only, my lord, interest, on the government side and PSU side, we mostly pray that please modify, and usually we say set aside. Because, anyway, my lord, I'll not go into it, but
Lord, can
I am assisting only on a proposition of law. I wish your lordship finds a way to get the power of modification, but I think, my lord, adding words may not be the correct.
Lord, what I've, Lordship has got page 1A, my Lord, first.
Yes.
1A, because that, I'll come to the landscape later. Please come to 1A first. What I've suggested is, in 132, 34 to 4,
Okay, if the legislations which are brought, which permit modification, is there any restriction on modification?
no,
There's a blanket,
no,
the absolute,
pardon me?
is there is no restriction or qualification for modification.
No, in 34,
Where modification is permitted in the foreign jurisdiction,
under 142.
under the arbitration acts of those, arbitration laws of those countries.
Of 1940. No, I didn't follow. I didn't-
Foreign jurisdiction.
Apologies.
Foreign jurisdictions where the power of
Yes,
modification.
they say very,
Is there any
modify. Yeah, they say so, yes. They
It
very.
only says the contingencies in which it can be.
In fact, Ram Subrahmanyam has reproduced those
It,
sections.
my lord, I have given, my lord, about 14 to 15, where it is other than UNCITRAL model, and thereafter I have given, my lord, another list in the,
We were interested where the power of modification, say in Singapore or in,
Expressly mentioned modified.
yes.
We'll get-
But
and
is
give
it
contingency.
hedged with conditions?
conditions also, that it can be modified, varied, on, if following is present. It's not uncanalized,
It's
so to
not,
say.
it's not blanket power.
It's not blanket.
Lord, one suggestion I made, Lordship may kindly see. Please come to my note page 1A. Now come to B, 32 to B. I am requesting the court to add the words
38 of my submissions reproduces the jurisdictions where there is a specific power of modification with contingencies in which it can be done. 1(8).
You also read some of those provisions.
Yes. 1(8) to 38.
Yeah.
Yes, but I read.
UK.
No, but
Right.
we didn't read out the conditions which are there.
Yes, my lord, please, my lord, have a look at, just by way of an illustration. Lord, page 22, this is United States of America.
Just take it.
Section 11, your lordship gets, my lord? My lord, this is, which one happened?
Page 18.
Yes, section, page 22.
22.
22. I'm just giving an illustration. This is USA, same modification or correction grounds order. In either of the following cases, the United States court in and for district wherein the award was made may make an order modifying or correcting the award upon the application of any party to the arbitration where there was an evident material miscalculation of figures or an evident material mistake in the description of the person, thing or property referred, where the arbitrators have awarded upon a matter not submitted to them, unless it is a matter not affecting the merits of the decision upon the matter submitted, where the award is imperfect in any matter or form, not affecting the merits. Let's. My lord, UK, my lord, if your lordship sees, which I read, my lord, page 19, substantive jurisdiction, I'm sorry.
So modify.
19.
Where the award is imperfect in form, not affecting the merits of the controversy.
Correct. My lord, please see 19 is more closer, my lord, to your lordship's query. 19, page 19, that is UK. My lord, first it defines what is substantive jurisdiction. My lord, page 18 bottom, competence of tribunal to rule in its own jurisdiction. Unless otherwise agreed by the parties, the arbitral tribunal may rule on its own substantive jurisdiction. That is, whether there is a valid arbitration agreement, whether the tribunal is properly constituted, and what matters have been submitted to arbitration in accordance with the arbitration agreement. Now, if we challenge, if I challenge it on that ground, substantive jurisdiction, then, my lord, section 67 applies, subsection 3.
This is with regard to the, you see, now this is very specific. Here, the power of the tribunal or the high court or the court in the 34 in India is also very wide. In India, under 34, it's very wide.
Correct, but here there is, my lord,
Because that's a full substantive review. It's not confined to arbitral review.
no, correct, my lord, point is different. Subsection 3.
So
On an
subsection 3 will only apply to,
substantive jurisdiction.
or substantive jurisdiction is only relating to the existence of arbitration agreement, constitution of the arbitral tribunal in accordance with that
And what
agreement,
matters have been submitted.
and
so-
the matters covered by. So in that case, there is no difficulty.
Lord, please,
There we can do it. There, let us put it, we can do it.
no, please see 69. Page 20. Appeal on point of law.
Yes.
But same arbitral award can be subjected to appeal on point of law. And please come to page 21, subsection 7. On an appeal under this section, the court may by order confirm the award, vary the award, remit the award, set aside the award. Because it's an appeal. The statutory intention is to provide for an appeal if it is an appeal on a question of law.
My lord, one thing is, if your lordship sees 34 to 1 to 3, 1, 2, 3 and 5 are tick box. Yes or no? There is nothing to be discussed. Agreement not there, party incapacity, and 4 is composition is bad.
Let's give another, not case specific. Let's give there are two clauses. One clause says so much amount will be payable. The second clause says this amount plus this amount will be payable. The arbitrator, therefore increasing the amount. The arbitrator holds this clause will apply. A plus B will be payable. The court holds it's patently illegal. In fact, the other clause is applicable. Can the court not give it,
Can the court not?
give the lesser amount? Answer will be no, in case we say we can't verify or modify the order.
That's the intention, Manu. That's the legislature.
But the,
It
but the-
should,
My lord,
it
again,
should have the power, but it does not have the power. That's,
whatever it is,
yes.
rule of law means that we follow the power.
Yes.
my lord, again, one possible view could be that if the arbitral tribunal was entitled to take a possible view, merely because this court thinks another better view is there, this court.
No, we are not going by that. I said, subject to the condition, this court finds is patent illegality. This clause is applicable, in fact.
Very well. Lordship is right. Suppose, for example, a clause is applied to situation X where it was never intended to be applied. And court can say, all right, you applied this wrong clause to the extent you applied it to situation X, I'm setting it aside. Perfectly fine. But suppose I'm giving a further example, Mala. What I'm submitting is, as far as modification is concerned, the difficulty is going to be where do we draw the line?
Yes.
I'm just giving the suggestion so that by next week we can also think about it. Kindly see, as far as 1A is concerned, I'm saying a lordship can add the word and to the extent, meaning that under 34(2)(b), if what are the grounds on which the court finds, what does the UNCITRAL model say? Please see very carefully. 34(2) has two parts. It has clause A and clause B. What is clause A? Clause A is a party making the application must establish. So the burden of proof is on the party making the application. That's what the UNCITRAL model says. Whereas B, the court finds. Even if the party making the application is not there, but if the court finds, once the award is before the court, if the court finds that the arbitral award is in conflict with the public policy of that state, it can set it aside. So the UNCITRAL model makes it very clear. There are two classes of grounds. One is a ground where the party must apply and make good submissions. And the other is a power reserve.
You added the words to the extent.
Yes, I'm putting in italics. I'm suggesting that.
But that will make another problem.
No, I'm just giving suggestions. We'll think about it.
In B, probably somebody can argue even when application is not filed, you can still invoke it.
Pardon me?
In B,
No. What I'm submitting is.
B, you can still argue if application is not filed under one, you can still argue.
No. There's no question of the court so motive. What the United Nations says is, if an arbitral award comes for enforcement.
If the court finds.
No, Lordship will kindly see. Yes. Maybe set aside by the court only if the party making the application establishes. Now B, I'm saying, and to the extent the court finds. I'm saying because under A, there is no partial set aside. Under 34(2), there is no partial set aside. Only in 34(2)(a)(4), there is a partial set aside on severability. If some grounds can be set aside, can be severed, then they can be set aside. Please see the proviso to 34.
To that extent, probably that item, that even we can extend it, even if not covered fully by.
Yeah.
But as long as severability is not, does not destroy the award itself.
So I'm putting that. Now, the more important amendment is in 2A, because today the major practical problem is in domestic arbitration. And please see 34(2)(a). I've given two suggestions.
He says important amendment.
Yes, I'm
Can't
saying.
be amended.
No, I've got cases where Supreme Court has done it. I'm not, something saying. Lordship will kindly see. First suggestion, and I've got a second suggestion at the bottom. An arbitral award arising out of arbitrations other than international commercial arbitrations may also be set aside. Now, I've added the words wholly or partially, or modified by the court to the extent the award is vitiated by patent illegality. Why I'm saying is, this will enable partial set aside of the award. And also,
But,
Want us to treat it as a casus omissus.
Casus omission, when can it be provided by the court?
No,
When the plain reading leads to an absurdity, only in such an event the court can
I'm
supply casus
I'm
omission.
saying plain reading is giving absurdity.
May not be patently illegal. An award of 18% interest when the court feels 12 will be appropriate.
Yes.
May not be patently illegal.
Then it can't be set aside. It can't be modified.
Amendment won't take.
No, I'm only saying one you can set aside. Now we are all agreed that set aside includes partial set aside. All right. Now we still not defined what is the meaning of partially setting
So
aside.
you will have to first, this can be the alternate argument. First is already encompassed in 34.
Yes,
One, locate the
Yes.
power
yes,
in the existing statute.
yes.
So this is a huge amendment exercise.
Which I'm giving 8 examples in my chart. Kindly see my chart. I know what I'm saying, but I know that I'm not asking you to judicially legislate. I'm saying make section 34 workable. 8 Supreme Court judgment, they've added the words. Now, please see the first judgment, Gujarat Urja Vikas Nigam. Section 174 and 175 of the Act were completely incompatible. What does the Supreme Court do? Please see words added by the court. Addition of the following words, end of section 175, except where there is a conflict express or implied between a provision on this Act and any other law. So many words were added. And what's the reason given by the Supreme Court? If the words mentioned are not added to section 175, it will result in an irreconcilable conflict between 74 and 175.
So therefore, in order to make the statute workable,
Yes.
let us provide it, but here, such is not the position.
Section 34 is unworkable because you're only setting aside the award. What my point is, despite the amendment in 2015, huge problem in arbitration. If the award is horribly wrong also, court will say, I can't do anything. I can only set it aside. I can't give any relief.
No, these are head-on conflict cases. You see the last reasoning.
I'm saying, no, not necessarily.
Yeah, 174,
No,
175.
I'm saying what I'm submitting is there is a power to modify. Then your lordship may decide whether you want to do it or you feel it's not necessary. I'm saying that I'm not not putting a US amendment into this. I'm not putting a Singapore amendment. I'm not saying varying modified. Now, what is modified? Puranmal Lakhanpal, Article 370. Supreme Court says modify in the dictionary means minor changes. But they say in the context of Article 370, modify gives the president widest possible powers. It can be complete change. I'm not going to that extent of Puranmal Lakhanpal because I'm not under Article 370. I'm saying, Lord, we have to solve a problem. We are not here for any, it's not a seminar. Lord. We have to, how do we make arbitration work in India? That's my problem. When I give my Gayatri Balsami's case or Daras Khambata's case, majority award is gone completely wrong. Minority is there. Good. Supreme Court in Sangyong.
We have more severe cases, my lord. We have
Exactly.
lost cases where it requires a special brilliance to lose it, my lord. I have demonstrated that brilliance.
So that's why you should have sat here at the beginning. I was telling my friend not to go there, my lord.
My learned solicitor has not gone there. He has not read the last few paras of his submissions to your lordship. I'll be placing them a lot.
In fact, government
He's
supports
given-
modification.
He's given a good suggestion.
Yes, he has given both the sides, but
Yes.
he's given both the sides, but he pointed out the difficulty in case we give the power of amendment or modification to an award to the courts. It may be then virtually we step into the shoes of the arbitral tribunal, which may not be.
That should not be.
No, that should not be done. My lord, what I'm saying is, there's a practical difficulty. Where do you draw the line?
That's the problem.
One problem is wholly set aside is not a solution. Partially set aside is a partial solution. Can we go one step further and say, when you say partially set aside, what do? Can the court simply says, oh, this is wrong, I'm partially setting it aside. Why can't the court come and say, look, this is completely wrong. Supreme Court says A plus B is equal to C. I'll make it C, continue the award. Otherwise, only for that, he has to go back to the tribunal. Argue that point again.
I'll tell you very frankly, if the court is careful in that,
Sorry, ma'am.
careful while setting aside the award,
Yes.
and they clarify the situation, parties are then aware that if they go back for arbitration, this is going to be our fate. If they're careful, if the court is also careful and the parties are also guided well by the advocate.
Lord, I don't know which way your lordship will solve the problem, but it requires a solution at your lordship's hands. How your lordship is going to do it, we'll have to deliberate and think about. I gave examples. Now, please see the other sections where the court has said, and not just casus omissus, the lordship rightly put it, and casus omissus from the beginning, they say courts can't supply the words. But casus omissus comes where the court has deliberately, parliament has decided not to include it. I have already shown the intention of adding 34 was with modification. There was no modification till 2016. Now, if you can set aside the award on the ground of patent illegality, why can't you modify the award to the extent of the illegality? Remove that illegality alone.
No, the other angle would be the legislature, parliament has amended it on 2 occasions, 2015 and 2019.
Yes.
So
That gives a clue.
even after those 2 amendments,
Yes.
this provision has not been amended by the parliament.
It is amended, they proposed. 2020.
Yes. No, what I'm submitting is, I take a cue from what your lordship said. 2015 Parliament realized if the award suffers from patent illegality, judicial interference is called for. Is that actually okay? Now, what is the error? What is the defect? Patent illegality. What is the cure? Set aside the award. I'm saying if the problem is patent illegality, is setting aside the only cure? Can we not judicially craft a way where the patent illegality can be cured, but the parties are not relegated to a fresh award all over again? That's what the Lordship has
being the powers of the tribunal itself.
Pardon me?
The powers of the tribunal will
With
be
great
served.
difficulty, 34.4, no, 34.4 is only for ground for setting aside the award. Now, ground for setting aside the award, patent illegality, you go and tell the arbitral tribunal, this is patently illegal, you rectify it. Suppose he still says no.
No, suppose evidence is required, what do you do?
Pardon me?
Suppose evidence has to be taken.
Yes. Then you can't. Then you can't. Then you have to set this aside. Now, see, suppose, for example,
That's what my answer.
I'm giving an example. Suppose the arbitral tribunal refuses cross-examination. Refuses cross-examination, violation of natural justice. You have to set aside the award and send it back. Then there is no question. Lordship is right.
But that will come in clause 3 then.
Which one?
That would come in clause 3.
Otherwise unable to present the case.
Unable, no, there are many reasons. I'm just saying, what I'm submitting is there are cases where setting aside is the only way out. Like Justice Venkatramaya says, when you quash in certiorari, what do? You put it out of existence. When your Lordship allows the appeal and sets aside, what happens? The judgment is not there. Your Lordship judgment is in merger. So you may decide this award has to be set aside. It has to be quashed. No problem. But apart from setting aside, I'm only saying what is partially set aside, nobody is able to define. We'll have to find some answer to that is my problem. And kindly see some of the amendments, my lord. How the courts have judicially crafted it. And what Lord Denning says, that if I come across a section which Parliament never intended, I will not throw up my hands. I will be constructive and try to add words to it. That's a hot water case. I'll come to it.
Lord Denning also said that we can iron out the creases without
Yes,
altering the material.
Exactly. I'm saying this is, I'm C4 court estates. I'm only saying that I was about to say, I put in my note, what I'm suggesting is
But Lord
ironing out the crease
Lord
and not
Denning,
altering the fabric. I'm not saying, I don't go to say that you can modify beyond patent illegality. No. If there is a patent illegality, that is a jurisdictional fact. There must be patent illegality. Then what? What does the 34 code do? Set aside.
Coming to the, today's hearing, we'll have it on Tuesday. But try and finish it off on Tuesday.
I'll just take.
Just check up if there are any
Lordship,
foreign
Lordship
jurisdiction
is saying
decisions.
something you have to look up on modification, so we'll make a
Yes.
note of it.
Just check up if you have any foreign jurisdiction, decisions specifically saying, what do you mean by modification of an award? What
We
can
shall,
the do,
we shall.
what can the court do? What are the parameters under which the court can modify? Because the rulings or the provisions of law, as far as the statutory provision, the power of modification is not absolute. There's one thing is very
But
clear,
one-
even where it is confirmed.
One Puranmal Lakhanmal's case.
Only
it says
one,
the word
request
modify in the dictionary will
Instead
not
of
apply to
Tuesday,
law.
can it be Thursday?
Let it be,
No, there are,
let it be Tuesday with, no, with let's continue. The other side has to continue.
yeah, yes, my lord. I am also reliable. My lord, thereafter jumped several issues, my lord, but in our rejoinder, we'll assist you.
Lordship will just see this chart also. The